Yes, Mr. Mani. 40? Huh.
Since the contempt matter was pending,
That you can still put it without withdrawing it. You put it, come back, we will, because if you withdraw this, you cannot refile it. Then the question of limitation would come in. So-
limitation come, if subject to correction, Milord, limitation would come.
Then you give him a notice
Absolutely. You have to give it-
and bring it back. We'll adjourn the matter for some time.
Otherwise, we have to file an RTR application now.
Okay, be here when the matter is come. Okay, on the prayer of Mr. S. Bonik, learned counsel for the petitioner, registered to list this matter again on Heg Dui Tini Kundina Pari 5/9/2025. On that day, we will say 5/9.
The consent on the other side. I'd like to mention item number 50. Then an adjournment slip.
You are 40?
Respondent number 2, Your Lordship.
A prayer is made on behalf of the respondent number 4 for an adjournment in the matter on the ground of
Out of station, Your Lordship.
the arguing counsel being not in station today. Full stop. Prayer is not objected to by the learned counsel for the petitioners. Registered to list this matter again after 2 weeks on a date to be fixed by it. Interim prayer, if any, to continue till the interim prayer passed earlier to continue. Interim order passed earlier to continue till the next date of listing. Yes, Mr. Soma.
Last item. No, I have
No, I want to have interaction in this matter because today, see, I've been going through the files yesterday. Nagaland, this is done with, but you have a further prayer for Assam. But you have not laid down the modalities how we will go forward with that. What orders you would like to have, because the orders again should not bar the railways. So that is a gray area where I would like to hear you for some your opinion on that. No problem, no rush. When do you want it? Date okay, but by slip huh? The matter was delivered. They were fixed for delivery of orders today. However, Mr. P. Sharma, learned counsel, appearing for the Directorate of Assam Mineral Development Corporation, submits that he would like to make further submissions in the matter. Prayer accepted. Registry to list this matter on board delivery. 99 or 90. Delivery order. To me, that DD by she'll give it.
Except 8, my lord. I said 8 of September.
8 Monday ke na baki je kunde. 8 Monday we will not give it also. Because Mr. Your issues we have taken care of. But the grievance, the apprehension raised, that also we'll have to give it a some observation at least, that how they would go ahead. Because I don't want the thing to be done in the railway yard, because that will again lead to congestion. So some modality you think about it, let me know, we'll incorporate it.
Mechanism is required.
Some mechanism. And the appropriate word would be Assam Coal SOP. What it would be. Okay?
Oblige.
Date, she'll give a date. Item number? You are for the respondent number? A prayer is made on behalf of the respondents number 2 and 3 for an adjournment in the matter ground.
Padri is out of station.
On the ground that the arguing counsel is out of station. post of prayer is not objected to by the Learned Council for the respondents. Registry to list this matter again in the second week of September on a date to fix by it. Second week.
Can it be on 11th?
It will come. Let the registry see. Yes.
Separately note,
Huh.
I'm here, madam, but there is a matter before court number.
Yeah, I only want the note, that's all. And you can just give it, you can leave. When the respondents come, I'll collect their note also. You can give it to her. Yes. Yes, Mr. Kapil.
Wait, your lordship.
This is with regard to that compensation.
Compensation.
You approach the district authorities.
Lordship, if I may so, Lordship, I have approached the district authorities, Lordship.
Ah.
What has happened is that, Lordship, there is a calculation, assessment has to be made. What is the compensation I will get? That assessment has not been done.
That assessment would be made by the district authorities.
If I may show your lordship.
I can't make their assessment, and if that is, no,
I'm asking for direction to the district authorities only, Lordship.
No, if that assessment is not proper, then you will have to approach the district judge.
District judge, Lordship. But if I may take your lordships to page 11A7 of the repetition, Lordship.
1-1.
Just one, Lordship.
Hmm. Yes, what is your stand?
Lordship, there are the,
Then they'll have to go before the district judge.
Lordship comes to page number 118, Lordship.
Hmm.
This is an order by the Deputy Commissioner, Lordship.
Hmm.
Uh,
The committee was constituted.
committee was constituted, Lordship, for assessment of the
What did this committee do thereafter?
nothing, Lordship. Committee was constituted, nothing was done, Lordship. Only if Lordship comes to page 120, the thing was.
There were similar orders passed by this court.
Yes, Lordship.
You have
I
a,
have annexed one of similar orders. It's a direction, if a direction goes to the district authorities, Lordship. I think
that much only we can do.
That would
You
suffice,
mean to say the orders at page 151?
Lordship. Just 118,
100?
125, Lordship.
And what is this 151?
151 is a recent order, Lordship, passed in regarding right of way, Lordship. However, when we communicated the said order to our concerned district.
This is pertaining to the same writ petitioners.
No,
No, different.
Udalguri district, Lordship.
Hmm.
So when we communicated the same order, Lordship, what has happened is that Lordship, the Deputy Commissioner forwarded the implementation of the order to the BTC Secretary. Thereafter, BTC Secretary again said that, no, we are not doing this, you do it.
He'll have to do it.
So he forwarded it again back to the, this one, Lordship, apna District Commissioner, Lordship. And then finally, at page 158 is the order, Lordship,
Hmm.
where the circle officer was directed. It is dated 16 September 2024. But nothing has,
What happened after this?
nothing has happened, Lordship. That is why we are before, Lordship.
This is also pertaining to the same area where your land is situated.
Saying to the same area where I am, my land is this under Baksar district, Lordship. That is why I am before your Lordship. Lordship, a direction to the district authorities that they may.
Who is appearing for the BTC? Any objection? That is it. We'll dispose it of that, directing them to approach. You will have to file individual representations before the deputy commissioner. He'll dispose it of.
They should consider it a fixed.
We'll give a time frame. Namgita will dispose of. Namgita will.
52.
Hmm.
Appearing from respondent number. Thing is that, my lord, these An appeal, my lord.
Raise that point. It's a question of law. Raise that point. Now you raise it. What is it?
Well, I pray for 3 weeks. I
Why? Why 3 weeks? Why?
the notice, my lord, very.
Seen the office note dated 28/2025, which reflects that the respondent number 1 has entered appearance by way of filing through an counsel. Respondent number 1 through a counsel has entered appearance. Full stop. Accordingly, steps upon the respondent number 1 is complete. Full stop. A registry to list this matter again for admissions on 8 তারিখে পারি কোনদিনা পারি মঙ্গলবার নিদিবা 17/9/2025 it's up to you.
The requisition proposal was taken by the government, not acted upon. Now affidavit says that process is going on, my lord.
What process was taken? What was going on?
Yes,
What
my lord.
is
Page 20, my lord, Annexure F.
20?
Is a
Hmm.
for embankment, my lord, land was requisition, but that's a highland, so they have abandoned an idea. Then proposal was come from this government that de-requisition.
So your case is that the process is still in the stage of requisition. No acquisition has taken place.
Yes, but no compensation is covered.
No, whether it is in the stage of requisition or it has been acquired.
Requisition, my lord.
Where? How do you say that?
My lord, their communication says,
But what about the affidavit?
affidavit, my lord, page 31, kindly see. And then,
If it is in the requisition stage, how was it made khas?
yes, more than 5 years.
How was it made khas, Mr. Burwa?
My lord, that is the problem, my lord,
That is the problem because the land is already acquired. It's LA case.
my lord.
It's LA case. It was acquired.
Yes,
So
the-
now where is the question of refund? You will get the compensation. Leave the land.
My lord, they are for 80 years, they are there.
Well, I can't help it. Madam, what is the stage?
There
It's
are
acquired. But where is the question of de-requisition when the process of requisition is already whole, you are acquired the land? If it is requisition not utilized, how did you make it khas? Then
That is the mystery.
what is the facts here? Your affidavit is also, you have registered a land acquisition case. Then you say in one place that you have acquired the land. You have made it government khas land. So where is the question of giving him back the land? You pay him the compensation. Ms. Burman, this is very vague, your affidavits. Whether it is requisition or whether land has already been acquired. Ms. Burman, heard Mr. M.J. Burwa, learned counsel for the petitioner, also heard Ms. M. Burman, learned government advocate, appearing for the respondent number 4 and it should be 5, it is 6 here, and 6. Ms. Burman submits that she be granted time till 15/9/2025 to receive instructions with regard to the status of the land of the petitioner as to whether the same was acquired by the respondents in pursuance to LA case number 17/71-72. That is the only LA case? Full stop. Registry to list this matter again on 15 questioning, 15/9. I would complete the instructions by on 15/9.
Yes.
Yes. Yes, Mr. Do you have the records? No. The records? Huh? Yes, Mr. Chaudhary. What have you found? Clearly. So that order would require an interference. Because this conclusion, as stated by the respondent of the Assam Gorkha Sammelan, Baska District Committee, caste status of so-and-so male degraded by intercaste marriage system to the lower caste. This is neither here nor there. Who is appearing for the petitioner, Mr. Sarania? Where is he?
Next, your lordship.
Yeah. That's all. Let the state level scrutiny committee take a proper decision after hearing the parties and following the procedure mandate. We'll just hear Mr. Chaudhary, you need not be here. We'll record your submission. And we'll hear Mr. Sarania and then pass appropriate orders.
Hearing for the respondent.
Mm. Yes.
It was issued on 23/11/21 for to hire 34 brand new cars to the respondent. Thereafter, the last date of the bid was
The matter is ready for disposal. Can we take enough?
Challenges to an
No. The question is, can we take up this matter for final disposal today? Mr. Sharma, you are ready? Your pleadings are come on record. Then we'll hear the matter and dispose it of. Yes. Yes, Mr. Gugul.
respondent issued a need on 23/11/21 for hiring
What is the issue? Now, what is the matter tender for? Hiring of vehicles.
of trucks, buses.
Hmm.
The last date signing of the closing of the bid was on 14/12/21 at 11 AM. The petitioner submitted the bid on 1/12/21.
When was the bid issued? Date of NIT?
On 23/11/21. The last date of the bid was on 14/12/21.
14, 12.
12/21. On 1/12/21.
Hmm.
We have submitted our bid.
The
Ah.
portal was open for submission of bids from which date?
And subsequently, the corridor was issued by the respondent authorities. It was accepted in the clause 2.11 was changed, page 35.
Hmm.
Down below, notes to clause 2.11. Similar work means providing transport services involving heavy passenger vehicle, buses, heavy vehicles.
Where are you reading, Mr. Gugul?
Page 35.
Hmm.
Below, notes to clause 2.1. This was changed. Similar work means providing transport services involving heavy passenger vehicles, buses, heavy vehicles, logistic equipment, or any other transport services. Earlier, it was not there.
So this is the amended one.
Yes.
Where is the earlier one?
The amended, this is the earlier one.
Earlier.
The amended one is on page 133.
So this is the case.
or any other transport services engaging heavy vehicles. This was included after submission of our bid. Your Lordship may see page 23.
Just a moment.
Page
This corrigendum is dated 10-1, 10-12.
12. You may see page 23.
Just
mean-
a moment, Mr. Gugoi, you are very, you are competent, you know your facts. Let me also catch up with you. Okay, so there was an addition to the word, the term similar work by the corrigendum by adding the words or any other transport services engaging heavy vehicles.
Yes, sir.
That much only.
Page 23.
Ah,
Page 20, amendment of bid documents, 4.0 clause.
Hmm.
The 4.2 I'm reading. The addendum will be uploaded in Oil's e-tender portal in the technical artifacts under the tab amendments to tender documents. The company may, at its discretion, extend the deadline for bid submission. If the bidders are expected to require additional time in which to take addendum into account in preparation of their bid or for any other reason, bidders are to check from time to time the e-tender portal, technical artifacts, under the tab amendment to tender documents for any amendments to the bid documents before submission of the bids. So we have already submitted on 112.
no, how does it affect you?
Because the what is heavy vehicles, we cannot comply with it because this what
Why was your bid held to be non-responsive?
they say because we conduct the technical bid.
You were held to be non-responsive in the technical bid.
Yes, because
Why? Ground?
because our
Show me the ground.
of the affidavit, page 370, para 19.
Para,
19.
page.
Page 370. The dependent basis stated as per BEC, BRC clause 2.1.5 of the tender number. So apart from the expense of providing attached browsers, tankers of capacity not less than 90 KLS to Oil India Limited, the bidder must also meet the experience of similar work against one contract of minimum rupees 39.5 lakhs in PSO central government organization, state government organization, corporation in previous 07 years to be reckoned from original bid closing date within the period of 15/12/14 to 14/12/21 as per BEC BRC clause number 2.1 of the tender. the BEC BRC clause number 2.15 is a note to the clause number 2.1 of the BEC BRC of the tender. It is to be noted that although the petitioner has experience for similar service, however, it does not fulfill the requirement of the requested one contract value for rupees 39.4 lakhs. The work done by the petitioner for providing the attached browser tankers was rupees 22039,441.90, which is less than the tender requirement of rupees 39.4 lakhs. Hence, upon necessary clarification and confirmation from the petitioner, the bid of the petitioner was technically rejected for non-fulfillment of the expense criteria for one contract value for a minimum of rupees 39.4 lakhs as per BEC clause number 2.1 of the tender. But we have fulfilled this condition. We are provisionally selected. Initially, we were selected as by the responding authorities. In my affidavit, I have stated the affidavit reply.
There was an amendment to the writ petition. So this reply pertains to the
Yes.
earlier
Yeah.
application, earlier writ petition.
But-
So I think it will not be.
I filed a reply.
The criteria that he has to meet is at page 35, 2.1.1. And that is similar work against one contract, if any, using the same vehicle as deployed against the original contract without or minimum 13.6.39. And that had the definition of similar work is in 2.21 clause Roman 1.
Yes.
It says providing transport services involving light passenger vehicles, buses, heavy vehicles, logistic equipment, or any other transport services. Now you amended this, page 133. Now, light has become heavy. Huh?
These are ultimately buses.
Huh.
Now, this amendment, he'll not have amended the NIT or the terms of the. But what is the condition of amendment? The original NIT has to be looked into. The original condition was for amendment says
Okay,
prior to the deadline of submission of bids.
got it.
So he was given the chance to again.
Mr. Sharma, we have got it. Now, the similar work will have to comply with the amended provisions. So he has given you certain documents which says that he has a particular nature of work he has done. Now, be that as it may, he submitted his bid immediately after. Thereafter, you took a decision, extended the time. He submitted. Now, did he submit documents in satisfaction of the corrigendum similar work? No,
He met only till the beginning of 20 lakhs.
20 lakhs.
20 lakhs.
Mr.
So it was
Gogoi.
technically rejected.
Mr. Gogoi, we'll come to the other part. Now, show me from documents that you had the requisite experience of 36.39 lakhs.
In my affidavit reply filed on 19/10/23,
Page.
page 337, para 9,
337.
337, 337. As regards the statement made in paragraph number 6 of the affidavit application, the deponent reiterates and reaffirms the statement made in the instant petition, more particularly paragraph number 5 to 11, and further back to state that the deponent fulfills the requirement of the requisite one contract value of which 39.45 lakhs according to need dated so and so. Prior to the current dated so and so, the Oil India Limited entered into a contract with the deponent via contract number so and so, that the bill tracking reference dated 3/8/21 pertaining to contract mentioned the cumulative value for contract is 43 lakhs 70,316.83, which fulfills the requisite criteria for one contract value for rupees 39.44 lakhs. The annexer is page annexer 9, page 351. 350, 351. This is one of the document,
351.
350 and 351.
351. Yes.
Cumulative value for contract is 4 4370,316.83.
Hmm.
And in my repetition also next,
And you have been released this payment within that time frame before 7/12/21. Then
and in my repetition,
this tender, is it stalled by this court? What happened to that?
For 4 years,
Ah.
and on March, coming year, it is going to expand,
But still there is some time.
around 7 months.
7 months. Okay, yes, Mr. Gogoi. So this is your case, that even if in spite of the change of the criteria, you fulfill the criteria, heavy vehicle you have operated, and you have achieved the the minimum of 36.39 during the last 7 years before 7/12/2021. But your case was rejected.
Rejected initially.
Ah.
We were rejected.
Okay. Where is the tender Minut's rejecting his bid, Mr. Sharma? Have you brought it on record?
Affidavit has not-
No. Your subsequent affidavit, what is your stand?
Our stand is that paragraph Lordship 19,
19.
it's 370, paragraph 19. That has been shown by our stand. Technical Evaluation Committee has.
Now he says, what do you say about the submission of Mr. Gogoi that he had around 43 lakhs with you itself? And Mr. Gogoi, have you made a averment in your writ petition that this document was placed along with your tender before the authorities?
so, yes.
That you fulfilled even the criteria now coming into operation with the corrigendum. Where is that?
Para 9, page 9 of the petition.
Yes. What is your response to para 9, Mr. Sharma?
Paragraph 26, Lordship. at page 370.
Just
One word. The value of 39.45. But he has given is multiple works now. And that is how he doesn't meet that criteria. Compared with the original clause.
$376.
Has to be one singular work valuing 39.4. But he gives us multiple works.
So the attached browse tanker thing, you accept. For Lexicon Engineering, the attached, you accept that. That-
Ask him to provide us a document.
So you accept that, although the work was not in his name, he had given his vehicle to some other contractor. So the vehicle in question was operated. So you accept, but you say that it is only 20.39. Then what about this 43 lakhs thing he has raised?
Three.
Page, where is that, Mr.
Paragraph 9 of my affidavit in reply. Page 337.
337? Come to the last 6 lines. And your cutoff date is December 2021. This is a contract of 3/8/2021. Done. Why was this not reckoned?
Has to be one completed work.
He has, where do you say completed work? You can come. If that value of the work is, and he says that before that date, he had received payments of 43 lakhs, right?
Yes.
Before December 2021.
They are contract only.
Come to page 35. The bidder shall have experience of similar work,
One contract.
contract. Same vehicle against original contract without any time gap of minimum so and so. Previous 7 years reckon from the original bid closing date, that is within so and so to so and so, both days inclusive. So he must have earned 36.39 lakhs in a 36.39 lakhs. That is the minimum. 35, 2.1.1.
Yes, Lord, sir.
Page 35, 2.1.1, that is the criteria.
Was 2.1.1.
Bidder shall have similar work, experience of similar work against one contract of minimum value 36.39 lakhs. Is it error?
39.45 is what I received.
Okay, that amended writ petition. Okay, same thing, 39.45. Till 14/12/2021. Huh?
This particular document is seen as filed in the reply.
Huh.
The figure
Huh.
my instructions, as I'm receiving it, probably this document was, I do not know. I have to then take my instruction from.
What is this? It is your own document. This work was done by him with you only. So how could you have kept him out? That rejection would be perverse. Where is that document, Mr. Okay, where is that document, Mr.
I have a document.
Page?
Yes, yes. I do.
You just show me 350.
Page 353.
351.
The original document is 353.
Okay. So this is a document which envisages payment of, this is the amount you received.
Yes,
I'm asking you again. This is the amount you received, Mr. Gugoi,
yes, yes.
on 3/8/2021. Then, yep.
Page 351, Lord.
You come to the original.
Value of the contract. This is the cumulative value of the contract is 43.
Okay, he says that this is, Mr. Sharma, that is what we want to know. He says that he has received this amount, 43, before that. And you come to the original 353.
Is 707. No, this is a card. Amount that is received.
354, come to 354. Kindly have this clarification.
And if you also see the last column,
Hmm.
giving the value of the contract.
Hmm.
It gives the contract price, the contract value. The
Hmm.
contract incomplete work, wherein he has got a part payment of only 10.
So get this clarification, whether he projects in his reply at page para 9337. He says that
This is that
cumulative value of contract which fulfills the so and so, so and so. So if he has received that amount as of December 2021, then he is eligible.
Worship, please see, it will be clear. Notes to 2.1, bottom part, surplus 2, last portion,
Page.
page 35 and 36.
Hmm.
The bidder, 2.11, clause 2,
Hmm.
bottom part. The bidder must experience of providing similar service to the public sector undertaking, central government organization, state government organization, government corporation for any length of time during the last 7 years ending on 14/12/21, original bid closing date. That is for any length of time within the period of 15/12/14 to 14/12/21, both days inclusive. During this period, 7 years, bidder must successfully carried out one similar work of the minimum rupees 39.44 lakhs. Accordingly, the starting date or the job completion date of the work did not necessarily fall within the 7 years period.
Mr. Gogoi, that is exactly what I'm saying. Forget the period. Period is of no consequence. But if you have received 39.45 lakhs in particular work, one single work, before December 2021, you are eligible. Otherwise, you are not.
Last part. But the value of the work must be requested amount within that period.
Huh, that's it. That's exactly what I'm saying. That can be the only interpretation. I've not seen this, but that can be the only interpretation. One work, 39.45 within 14/12/21. Show me that.
Yes,
You have made a statement in paragraph 9 that you had it. You had it in August 2021. Let him have his instructions if that is correct. If that is correct, we will allow you. Or if not, we will dismiss the petition. That's all.
I just need to explain these last receipt.
No, I want to know whether before 14/12/2021, the petitioner has received 39.45 from that one, from that contract.
Half an hour loss.
I'm praying for a short accommodation. Could it be taken up on Tuesday next?
Mr. Soikia, the only problem is
Or if
Tuesday, this next week and the week thereafter, there are many matters fixed. The best earliest I can accommodate would be on Ketia, 2 tarik, 4 tarik, 9 tarik, 11 tarik kundi na pari. No, it will not be possible this side also. 11th. Before that, I'm sorry. Mr. Soikia, Mr. Chaudhary, but all the parties, this is that Joymal. One factor, there is already a committee constituted in Tripura, and that committee has been given a pan-India thing by the Supreme Court. Kindly, I was asking this on the,
Yes.
kindly address whether this matter can also be monitored by that committee rather than this court, because now it's a Supreme Court approved committee. But just give
In
me,
that
and
case,
what
if
is
it
the status of the elephant as on date? Who is appearing for the Tamil Nadu authorities?
Mandir, the Mandir committee has.
Huh?
I'm supposed to answer this question.
Yes. You are for the Tamil Nadu government. How is the elephant?
The temple is with the elephant temple, but then it is being monitored, supervised, and looked after by Tamil Nadu government. Periodically, there is inspection. Doctors.
Mr. Tiwari, would it be inconvenient to file a report with regard to the health? No, the latest report on the next date of listing,
It's up to
because we are only concerned with the health of the
the last
elephant.
The last report is up to 18th of March 2020.
So we want a report as of say 8th, because we are fixing this matter. Kiman tarika dilu? 11th. Huh? We'll do that, Mr. We'll do that. We'll hear Mr. Will not prejudice Mr. Soikia. Let him make his submissions. We'll take a call thereafter.
We are in before this on for interpretation of the law, existing contract, existing Wildlife Act, not on the status of the hill, the
Mr.
elephant at this stage.
No,
Wait.
the elephant health is for the
That-
court.
That is for the court, and elephant is finally kept. Now that is not the issue. Whether the state of Assam can
Can.
bring it back or not.
That is your
the legal
case.
issue before this honorable.
We'll
It
consider
is
that.
not referring to the matter to the committee.
Uh,
that is
Mr.
That is an ancillary issue, but the main issue is whether
You want
Assam-
it back.
we want it back.
Now, my lord,
But-
so far as-
The issue that was taken by this court, till that issue is
Yes,
resolved,
I fully.
the health of the elephant has to be
Yes,
monitored.
We fully appreciate
We'll
that.
be the parent of the
concern.
elephant now.
Fully appreciate, Lordship.
my lord, so far as the state of Tamil Nadu is concerned, our stand is as referring the matter to SPC's same page with Mr. K. Chaudhary.
Whether Tamil Nadu government is forcefully keeping it or they should return it to Assam.
Number
That
two.
is the question.
Number two, so far as handing over elephant to Assam is concerned, the answer is emphatic no. On that, my lord will decide.
Fine. That is why the dispute is with Mr. Tiwari. Mr. Tiwari, if the government of Tamil Nadu and the government of Forest Department of Assam was on the same page, this
government-
bulk would not have been here.
Yeah.
Mr. Chaudhary should not have come in as an activist to be here. Of elephant, means of animal right activist.
We have to take care of the concern of Mr. K. N. Chaudhary.
Okay.
On that, there is no quarrel.
The government of Tamil Nadu, they should have been only the facilitator of bringing it back.
Anyway,
They cannot be the possessor of the elephant.
on that issue, I'll address my lord.
We'll love to hear that.
Concerned, my lord, till
Mr. D. Soikia. The earliest I can do is Kimantari
If
Kola.
it is
11th of-
tomorrow also, I am ready to argue, Lord. If it is convenient, tomorrow at 2 o'clock,
Tomorrow, if the parties are ready,
I am ready. I'll be.
but this court would, I'll request the matter to be listed before an appropriate court bench. Because this court would not be there
No,
tomorrow.
no, no. Lordship will hear it.
There is nothing. If there is an urgency, why should I? Tomorrow, if the parties agree, we'll have it.
Tuesday then, Tuesday.
No, it'll be not before 11th. Because,
Tuesday in another court if it is.
okay. It'll come back to me only if.
The elephant
26.
should also come back to Assam, Lordship.
26 will not be possible, Mr. This will require some application.
Because that also have to appear.
Okay, let it be 11.
11th, Mr. D. Soikia, learned counsel, learned advocate general Assam, appearing for the petitioner. Also heard Mr. P.K. Tiwari, learned senior counsel, appearing for the respondents number 2, 3, 4, 5, 6. Also heard Mr. K. N. Chaudhary, learned senior counsel, appearing for the respondent number 8. Also, as agreed to by the learned counsel for the parties, registry to list this matter on 11th. Also, on the next date of listing, the learned counsels for the parties would make their would advance their requisite respective submissions with regard to the issues arising in the present writ petition. Full stop. On the next date of listing, Mr. Mr. A. Gogoi. A. Gogoi, learned counsel, assisting Mr. P.K. Tiwari, learned senior counsel, shall place on record a report with regard to the health of the elephant, as well as the circumstances where under which the accord, also with regard to the care being provided by the authorities to the elephant concerned. Full stop. The report be placed on record by the who should be providing it? The PCCF, the Principal Chief Conservator of Forest and Head of Forest Force, Tamil Nadu, after causing an inspection of the elephant, apostrophe Joymala. Registry to list this matter again on 11/9/2025. An endeavor would be made to dispose of the matter on the next registry. Mr. P. Monta, learned counsel, appears for the respondent number 9. Your name, ma'am? Can you just write it down? So and so appears for respondent number Mr. P. Mohanto, learned counsel for the respondent number 9 and 10, and Miss So-and-so, learned counsel for the respondent number 11 is present. So next day.
Not deeply
11th.
obliged.
But Mr. Saikia, also factor in your argument why this court should not refer it to the
Yes,
your
that- it is
argument.
regarding the
Whatever
health
it is.
condition.
I'm not.
But here the issue is whether after 3 years, whether as per the contract and as per the existing law, it should be brought back to the state
So
authority.
when
That is the legal issue.
when you are making
Regarding the
that
ownership of the,
when you are
Yes,
making that
well,
legal issue, kindly also factor in this orders of the Supreme Court and the Tripura High Court.
yes, that will have nothing to do here.
Just show that,
If
demonstrate,
it comes back to Assam also, then also that committee can look after the welfare of
Just
the elephant.
demonstrate that in your
We'll do
submissions.
that.
Yes.
Deeply obliged.
Yes, madam. This is the fight between two brothers for the share of the mother.
Big mother.
Tell me, what is the law? How do you get this thing transferred? What is the procedure?
There is a rule 20 in Assam Code.
Assam Cooperative Society Secretaries. We are taking it up for disposal, madam. Rule 20.
Petition lordship in the
Okay, fine, read.
petition where it is said that a member may, by writing under his hand during his lifetime, or by a statement signed by kept by the society nominated any person or interest in the society shall be paid and transferred
You are reading, madam, which provision?
lordship rule 20 of the rules 90
A rule to some rule. Here a rule to us, Assam Cooperative Society's rules.
29 madam. It petition.
Rule to us in here, madam. 29. Ah,
second lordship. Writing under his hand deposited with society kept by the society nominated any person or so much thereof as may be. Nominee may become a member only if admitted by the
kindly lead further.
nominee does admit. It may be- Then number 3, the name and address of every person one above shall be entered in the register of members. Of the petitioner lordship, he is the shareholder of the shares. Pinapani Cooperative Society. Ship on 8/10/2020. Cooperative Society. That application is in their lordship shows our willingness to nominate our second son, Dilip Borua. That is the
Can you read the vernacular one? 46. Honman Purvake Nibedan. Read that.
নিবেদন পিনাপানি
हमारे कमेटी पूर्वते डीट है
উত্তৰাধিকাৰী বিপুল বড়ো
पूर्वक दिया मशीन
এতিয়া মই নাম সলনি কৰি উত্তৰাধিকাৰী ভৱিষ্যতলে মোৰ গ্ৰহণ কৰিবলৈ অনুৰোধ
Okay.
lordship after her application lordship managing committee of the on 27/11
Page 50.
yes
Hmm.
that the as per the house anonymously resolved today to include the Borua as the legal heir
So that vernacular at page 52 says that because of the change from Bipul Borua to Dilip Borua, the managing committee accepted that.
Sir.
Okay, come to then what happened?
Then the managing
This is also by the managing committee only. Page 51 is managing committee.
Yes, Lordship.
Ajja Wahi Khaba. Huh. Then
Then Lordship, the managing with the Assistant Registrar of Cooperative Society. Appraisal and approval, Lordship.
Hmm.
Page number, Lordship 50.
Yes, madam. Got it.
Lordship, but what happened? Surprisingly, Lordship,
Hmm.
the general meeting.
Hmm. Hmm.
They, the nominations.
Where is the vernacular? Not very clear. Ditya Prostap, page 63. Not very clear. Okay.
Actually, it is page 50.
Resolution is at page
And Lordship, the operative House resolved who was their own bylaws law. That is clause 34. That if anyone has any problem regarding the decision of they'll prefer a lordship. But the decision passed by the managing committee lordship on 20 the decision of the managing after that lordship by the 7 court lordship.
with regard to the bylaw, madam, what is the provision? No, no, with regard to share, transfer of share, that is clause 15 onwards. Okay. Okay, what is that we want me to see? Page, the earlier order of this code. Page 110. Yes.
The court directed the register of
Hmm. Okay.
number 2.
Hmm.
Then lordship the respondent number 2 empower
Hmm. Hmm.
inquiry lordship. That is the order dated lord 8/10/2000. And lordship he found that the 7 resolution of that is improper
Hmm. Hmm.
and that order is in page number 1.
Hmm. And the operative portion is 113. Okay, then what happened?
Lordship further he died the director of the holding a SGS of this issue and then lordship a SGM is held on 11 to
So your case is once your mother has nominated you, nominated your brother, subsequently that nomination was cancelled and Dilip Borua was nominated. So the managing committee accepted it. Unilaterally, maybe basing on the complaint, the special body interfered with that, saying that no, that is defective. The board of directors did not have any jurisdiction. Then the matter comes up before this court. This court reverts it back to the registrar, but the journal registrar hears, he comes in your favor. Matter goes back to the special committee. Your case is Rule 20, once there is a nomination, the shareholder has the power to change it, and your mother had changed it. And from the first decision of the managing committee, it is seen that it was in their records also. That's your case. Okay. Yes, Mr. Biswas.
I will carry out the order.
Who is for the private response?
Between two brothers.
No, who is for the private, the other brother?
I'm here, Dilip Borua.
You're Dilip Borua. Okay. Now, tell me, Mr. Biswas. You are Bipul Borua. You were the first nominee. Why is the second nomination made by your mother in favor of the petitioner wrong? Or it's not in format? What is the error there?
In our affidavit, we will explain the matter.
Kindly take me, sir.
Para 2 of this, Madam Kali. I take. He said whatever was not born out of the record. As the opponent states that resolution of the general meeting dated 35/22 of Binapani Cooperative Stores Limited have been taken unanimously and have been duly approved by the board.
Where are you reading?
From an affidavit.
Affidavit by respond number 4. This is by the district deputy registrar cooperative societies. You are respondent number 9.
Binapani Society.
Where is your affidavit? 8. Respond number 8's affidavit.
Yes.
Where? Has an affidavit? No. Only affidavit is by respond number 4.
We have filed it, Madam. We have filed it, Madam.
Filed by name?
Secretary Binapani Cooperative.
What is his name?
8
Singing also. When did you file that, Mr. Biswas?
Indication on the mobile file, it indicates that it was filed on April 25.
Madam, have you received?
My record lost it.
Respondent 7 and 8.
7 and 8. That is Binapani cooperative societies. Nobody is appearing for 9. Nobody is appearing for 9. Okay, what is your stand in the affidavit?
We have taken up the matter in our meeting, my lord.
No, I'm not on that. Your first general body says that the application submitted by the mother in favor of Dilip Borua was defective.
Addressed to Samobai Samiti, our address to society, store, Binapani store.
Okay. Okay. Let us have that.
Petition, your lordship.
That is there. Madam, where is that letter of your mother?
Lordship.
48, 49. Okay, vernacular. Mr. Biswas. Okay. So the projection can be that this was never received by us. if you have received it, you have acted upon that also. So the mere by making a wrong reference that lady may not know, she had made it.
Projected by the sun. so they
No, they,
could obtain money.
no. Now you come to page 54 of the writ petition.
Copy of the resolution.
Hmm.
The Board of Directors, Vinapane Stores Limited, which is held in the office of the stores today. Application submitted by the Eastern Registered Cooperative Society, I see Dilip Burua, chair of the state Kamala Devi, is read out in addition to the application submitted on I Sri Bipul Burua, the former heir of the deceased shareholder, praying for the transfer of the share of the deceased, also read out in the today's meeting. After having a detailed discussion over the issue, even though the House applicants, that is both the, to reach to a consensus in this regard, but both of them have kept demanding that share should be transferred in their respective name, hence showing reverence of the application of 2810 to
That is what. So that application was held by you to be a proper application.
though we have taken the plea, my lord, but we have considered it, yes.
So that's the end of the matter. He
Sir,
satisfied the,
that even we have to make shareholder both the brothers.
no, only one, because that subsequent, that earlier nomination is superseded by this, and that is your understanding also. The earlier nomination, whatever was there, that stood superseded by page 49. Yeah, if we can come back to the, we can come back to the
49.
49.
Yes, দ্বিতীয় পুত্র বড়ুয়ার নাম
She is very specific. পূৰ্বতে দি থৈ যোৱা উত্তৰাধিকাৰী মোৰ সৰু পুত্ৰ বিপুল বৰুৱা দিয়া আছিল। এতিয়া মই নাম সলনি কৰি উত্তৰাধিকাৰী হিচাপে মোৰ দ্বিতীয় পুত্ৰ শ্ৰী দিলীপ বৰুৱাক নাম দিলো। So the earlier one is superseded and that is accepted. So under section 20, you can't have all these things, dramas is of no consequence because law says that it is the desire of the shareholder. That's the end of the matter. Anything more, madam? A writ petition allowed. We are interfering in a direction to you to act in terms of the mother's application subsequent. Because she refers that she gave a nomination in favor of her elder son, younger son. Now she is giving it in the name of the, and that has not been superseded. That's the end of the matter. Namgita likhi logo. Madam, we'll have the order by Tuesday.
7.
Yes, payments made. So, Mr.
My lord,
Now
no
the
update
battle
on
will
my lord.
start.
Communication has been received, but
Oh,
in practical, no
that,
money.
Mr. A government paper is of much value. Where is that copy?
Like 70,000. Same copy we got yesterday.
So, Mr. Chutia, when is this money in practical coming into her account?
No.
But here this is not endorsed to the treasury.
Not a readable copy.
Authority, my lord, amount was under the council, my lord.
Now, my lord, it has not been transferred.
Mr. J. Chutia, Learned Planning Council, Karbi Anglong Autonomous Council, DIFU, submits that in terms of the undertaking made by the council before this council, the COUNCIL, before this court, comma, the sanction of the amount of the area salaries of the petitioner with effect from 25/1/2021 to 9/3/2023 has been already issued, and the amount involved has also been sanctioned for a release to the petitioner. He submits that the amount involved would be deposited in the bank account of the petitioner within a period of 1 week from today. A registry to list this matter again on 8/9/2024, on which date the parties shall apprise this court as to whether the amount has been actually credited to the account of the petitioner. Don't worry, we will see to that the amount is credited to your account, then take the next step that is required. Ms. MD Bora, Learned Counsel, appears for the respondent number 2. Etu, what দিব?
I appear for the petitioners.
Hmm.
The GST matter.
Hmm.
It's 2017-18 is the impuged period.
Hmm.
For 17-18 lordships, audit under section 65 of the Assam GST Act and the CGST Act was conducted.
Hmm.
A certain discrepancy was raised,
Hmm.
and post that discrepancy we replied, certain discrepancy came to be dropped and some amounts were confirmed.
Hmm.
Those amounts stood paid by us.
Hmm.
After payment of those amounts, a final audit report in
Hmm.
form ADT 02 was issued to me, discharging me of
Fine,
all
sir.
my liabilities.
Hmm.
My lordships, section 65 is a complete code in itself. It says, if on a completion of audit, if I don't pay the certain amounts, then department can proceed with assessment under 73 or 74. They can issue me a notice.
So under you, there was no amount, only an interest part was around 67,000.
Dropped
Dropped?
on merits. Contested and
67,000 odd was. Hmm.
which I paid.
Hmm.
Lordships, 17-18 was to be time barred on 30th of September 2023.
Hmm.
The time limit of issuance of show cause notice.
Hmm.
Suddenly, Lordship, on 28th of September 23,
Hmm.
a DRC 01
Hmm.
summary of show cause along with a annexure was uploaded in my portal.
That assessment of tax.
Assessment of tax show cause notice.
But was a proper show cause notice issued to you?
But I'll show you that in my view, it is not a proper show cause notice because
You're Mr.
Kanodia.
Kanodia. I'm just asking you a question.
Eh,
Whether a summary of the show cause was uploaded,
along with the working.
whether a show cause proper under section 73 was
sir.
given. Yes, Mr.
Lordship, but
That is the point, my lord.
Mr. Gogoi, the law is summary is an additional thing. The show cause has,
Saying, my lord. Point, my lord, I have no submission. Strike down taken by the
no, if it is the show cause only, you give him a show cause.
Lordship, now again remanding me back.
That
to
I will exercise my power.
Lordship, but today, what was my plea before your lordships is when an audit is already completed and there's a departmental circular to that extent that once an audit is completed, you cannot issue another show cause notice.
The period
It's same.
would have come to an end on 39. Technically, that was issued to you on 28/9.
Lordships.
So the power, that period, limitation period was there.
It was there, it was subsequently extended. I am not on that lordship. I am not on 168A also. It is
Only
not by-
thing, if your case is that 73 notice was not given to you.
Because it falls from your lordship, therefore I address.
So you're not interested with
I am
that
not
notice.
interested on
So that DRC for 01 is perfect.
I will take that as
Okay,
perfect.
we'll proceed.
Lordships.
Okay.
Lordship. Now, lordships, in the DRC.
Now, I'll not permit you to go back and say that the 73 notice not being issued.
Lordship.
The summary of show cause notice will not be
Lordship.
permissible.
Lordship.
You're waiving that.
I will.
Okay.
Because that was never contended by me in any of my grounds.
That's the position of law. Otherwise, okay.
I have come
I've
upon
held.
the lordship's judgment also when lordships had set aside the order and remanded it for fresh adjudication. Let's say that fresh adjudication after 7 years of GST again is something which one has to argue, maybe an
Continue.
appropriate case.
Continue.
So, Lordships, now when this show cause under 73 comes to be issued on, which is at page 46,
Hmm.
my Lordship may kindly take page 46.
Hmm.
In the DRC 01,
Hmm.
in the clause B, they say grounds, non-filer of GSTR 9.
Where do I get that?
Lordship, in page 46,
Hmm.
brief facts of the case, after summary of show cause before the table. Just before the table, Lordships.
Non-filer of GSTR 9.
Lordship, GSTR 9 is a annual return. Now, Lordships, in the subsequent page, page 48, which is an annexure to the DRC 1,
Hmm.
after the first table,
Hmm.
they have written, you have filed GSTR 9 for financial year 17-18. In the summary, they say, I have issued this show cause because you have not filed. And in the annexure, they say you have filed GSTR 9. So what the department intends to say, it is not clear. Self-contradictory show cause notice.
Hmm. Hmm.
First point, Lordships.
Hmm.
Second, Lordships, I'll take your Lordships to the definition and provisions of section 65 and the definition of audit. Lordship may kindly have section 2, subsection 13.
So what is your second point?
Second point, Lordship. Now I'm on the point whether this show cause notice could
We'll
have
come
been-
to the provisions of the
Yes,
act a little
My
bit later.
second point is, Lordship, whether a show cause notice under 73 can be issued once an audit for the same financial year is already completed and dropped under section 65(6). Having regard, and also, Lordship, having regard to the trade circular issued by the state commissionerate in this issue.
Yes. That's your second point.
That's my second point.
What's the third?
These are the two major points.
Two points.
Two major points. The
So
second
let's-
is the in fact the point of law, Lordship, which your Lordship will listen. Once
I
that-
think we should take up the second point
Lordship,
first.
that is.
Okay.
So, Lordship, for that, Lordship, may kindly first take section 2, subsection 13.
No, before that, kindly
documents.
take me through the documents involved.
Lordship, Lordship. Lordship, page 25 is the intimation of conducting audit by the department. The form ADT 01. Page 25.
This is for the financial year 17-18.
70.
Hmm.
So, Lordship, this is the list of documents that during the initiation of audit they asked for us, asked by the from the petitioners, and they have given that. Lordship, page 27 is there discrepancy BEBO audit observation in terms of the rule 101 sub rule 4.
Hmm.
After verification of books of accounts, whatever is their observations,
Hmm.
they have to give us in writing, which is at page 27.
Okay.
Lordship, so first paragraph, may I place this document?
Hmm.
Subject audit observation in terms of Rule 1014 of the Assam Goods and Service Tax Rules. In course of conducting the audit of the accounts and records of Messrs. This for the period July 17 to March 18 on 22/5 and 29/5, the following irregularities, discrepancies have been noticed, and the same is being informed herewith in terms of Rule 1014 of the Assam GST rules. First is short payment of tax in GSTR 9.
So
They-
GSTR 9 is there.
GSTR 9 is there, admitted fact. They say in the GSTR 9 submitted by the auditee, the following discrepancies have noticed. Total tax payable, X sum amount tax paid, X y amount tax short paid. In both the heads, CGST head and SGST head, they have calculated 16.28 lakhs each as short paid.
Yes, go proceed.
Lordship, the auditee has shown taxable turnover of rupees this, tax payable this, but the auditee has short paid the tax as mentioned in the table above. So this is the first discrepancy. Second discrepancy, Lordships, suppression of turnover as per records, books of accounts. They say they have in the next page, Lordship, page 28, they have given a table wherein they say 87,39,593 is unreconciled turnover. Means whatever I've shown in my books of accounts and what I have shown in GSTR 9 and 9C, this amount is unreconciled. So on this also they say you have to maybe you either reconcile or pay tax on this. This is, and this was the total, these are the 2 points in my audit observation, Lordships. Now, Lordship, I reply to this audit observation under the statutory framework, which is at page 29. Page 29 is my reply, Lordship, which was received by the department of 9th of June 2023. I reply first point, Lordship, in page 29, I summarize the two issues. One is the short payment of tax of 16.28 lakhs each. And point 2A is trade discount and unreconciled turnover of 87 lakhs.
You gave
Now-
your replies.
I
Okay,
gave
fine.
a detailed reply and post that detailed reply, which goes up to Lordship page 35, which goes up to Lordship page 40. It is until page 40 is my reply.
Now come to the audit report.
41. Page 41 is the ADT 02, which is the audit report, final audit report. Subject audit report under section 65(6), reference to audit observation and reply. Your books of accounts and records for 17-18 has been examined, and this audit report is prepared on the basis of information available, documents furnished by you, and findings are as under. 1. Short payment of tax. The auditee has discharged the liability of amounting to rupees this and this during April 2018. The auditee has disclosed the remaining balance with applicable interest. Hence, the objection is ignored. So first point, drop.
No, proceed.
Proceed.
However, the auditee
However,
has
the
made
auditee has made late payment of tax against the following invoices.
so
which
interest.
Interest has to be. So they quantify the interest.
Now
Except-
suppression.
Suppression of turnover. The auditee has satisfactorily replied regarding unreconciled turnover. The objection has been ignored. So ultimately, my total objections of the audit boil down to some interest short paid, and every other point dropped.
And this you have paid up.
This I have paid, the acknowledgement of which is at page 43. 43 is my covering letter to the department for payment. 44 is the DRC 03 showing the payments made.
Yes.
Now, Lordship, may kindly have the provisions. 65.
No, where is that? Thereafter that.
Thereafter,
is
the
it?
show cause,
At page 44.
page 46.
Okay.
Lordship, before I go take your Lordship to the show cause, may I bring certain the legal provisions of audit?
We'll
And-
finish up this then.
Okay,
go
Lordship, sorry. Lordship,
So here the show cause notice,
Show cause-
summary of show cause notice is a
Let's-
non-filer of GSTR 9.
8 now, Lordship.
Is
will
it
come.
for the same year, July 17, 18?
Same period, tax period.
Okay.
Page 48, they say you have filed annual return.
Okay.
And then they come out with the first discrepancy, which is page 48, serial number 1. Short payment under declaration of output tax, which was already considered and dropped by audit, which your Lordship has seen in the ADT 02 also. Unreconciled turnover, which was considered and dropped
Okay.
by audit.
Give me the provision.
Lordship. Lordship, second point is also there in that show cause. 1 point of input tax credit also is averaged.
If you are successful in the second one, the first one goes
Lordships.
65.
Lordship, section 65. Audit by tax authorities. The commissioner or any officer authorized by him by way of a general or a specific order may undertake audit of any registered person for such period at such frequency and in such manner as we prescribe. Lordship, before that, let us go to the what is audit. It is defined in the statute under section 2, subsection 13. And Lordship, first time in the legislature under the erstwhile excise service tax regime, there was never a definition of audit. This time the legislature has defined it in a greatest of extent, Lordship, which I would like to place. 2 subsection 13. My Lord says there. Audit means examination of records, returns, and other documents maintained or furnished by the registered person under this act, which is the CGST or the Assam GST Act, or the rules made thereunder, or under any law for the time being in force. It extends up to ancillary laws also. To verify the
Okay,
correct
come to the substantive portion. 65.
65. Lordship, then Lordship, 65(2), the officers may conduct the audit at the place of registered business. That is fine, Lordship. 65(3), the time period is given to 15 days notice. This is not objected. There is no objection to these, Lordships. 65(4), the audit under subsection 1 shall be completed within
This was also complied with.
complied with. 65(5), during the course of audit, the authorized officer may require the registered person to furnish afford him necessary facility to verify the books of accounts, to furnish such information as is required, which we have done. Now 65(6), on conclusion of audit, the proper officer shall, within 30 days, inform the registered person whose records are audited about the findings, his rights and obligations and reasons of such finding, which he has done via ADT 02. Now 65(7).
Mr. Counsel, that information is not a show cause. It's
Not a show.
only, it's a information only.
Lordships.
And they come to a final conclusion.
Lordships.
Section 73 has not come in.
65(7) will speak.
73,
Has not commenced.
it's only a provision under 65 for finalization of the observations of the audit.
Lordships. I
Right.
could out. I am in with Lordship.
Whatever happens there will have to be final under section 65 only. Now show me that this finality under section 65 would also debar the authorities from proceeding under 73.
65(7).
Okay.
Where the audit conducted under subsection 1 results in detection of tax not paid or short paid or NSC refunded or ITC wrongly availed or utilized, the proper officer may initiate action under 73, 74.
This is if it is found out therein itself.
And in ADT 2. So in my case, it was found out in ADT 2.
Hmm.
In ADT 2, they found out this
Then
is
they
Lordship.
reconcile that.
And
You
they
can-
Lordship, ADT 1, then discrepancy memo. Discrepancy memo, they list down.
you
I
give-
reply.
and
Now
they
they
come
give
to-
a final audit report. Lordship, for example, if we take in the ADT 2,
Hmm.
suppose my unreconciled turnover could not be explained.
Hmm.
So it would have remained in the ADT 2.
So it would
Subsequently,
automatically would have come
It-
within,
I should choose under
73.
70. Lordship.
but,
So-
but in spite of that, the audit report having come on record,
Lordships.
my question is the authorities debarred from further proceeding under 73?
That is well. I will answer that.
Hmm.
Lordship, audit definition. Once your Lordship sees 213, it says
It's
examination.
audit.
Audit. So audit encompasses a very wide structure under
Can you
GST.
come to section 73 for a minute?
73. Lordship. Determination of tax.
And Mr. Counsel, also make
Rules
your
of audit.
submissions that whether 73 can be done in a circumstance only basing on 65.
Lordship, no, Lordship, I'm not on it. I'm not on it.
But-
73 is an independent assessment provision. It is under demands and recovery. But whether department can exercise,
It has a power.
it has a power.
It is not encumbered by 65.
No.
It can be exercised within that limitation period by the authorities for a reason to be assigned by them.
But for the same reason for which has already been dropped by audit. That is my question.
Audit, that is audit 65.
Lordship, 65 audit, then Lordship, it will be parallel, multiple proceedings will go on. Lordship,
Okay.
statute cannot ask the SSC.
We'll ask Mr. Gogoi also on that.
I will place
make-
Lordship, I place the trade circular of the department.
Okay. So now only thing I want from you is the process under 65 having been
65,
closed,
sir, Lordship.
closed under with interest payment only. The authorities are debarred from opening,
Because of 65,
reopening
7.
that reopening that under 73.
Sorry, 73 is a provision which empowers the proper officer to issue a show cause. Now, before a issue of show cause, there can be an audit, there can be an investigation, there can be scrutiny of return.
And
61,
these,
65,
these
66,
are independent proceedings,
which leads to 73,
may lead to 73.
which may lead to 73.
Without that also they can go to 73.
Lordship, without that, there has to be a quantification first. On what basis?
Okay, we'll understand that.
Lordship, I will come to that. Lordship, now, Lordship, may kindly come to my a board circular. Lordship, first kindly takes my rejoinder where I have attached my a trade circular.
Page.
Lordship, it is at page 103. Lordship, this is instruction number 13 of 2023 GST issued by the Commissioner State Tax on 26th of December 23. Attention is invited to IT Big Data software which has been procured by Commissioner of Taxes Assam for ease of operation for their jurisdictional offices. With the help of the software, automated notices in GRC1 can be generated based on different parameters. Representations have been received that even though taxpayers who have been assessed for cases like scrutiny, audit, and advisory summons, but notices have been issued again in those cases for financial year 17, 18, 18, 19. But considering that in the initial years of GST implementation, a lot of practical difficulty were encountered, it is hereby advised to drop the proceedings keeping in mind the following instructions. 1. In those cases where audit proceedings have been completed, the notices again giving using IIT Big Data software needs to be dropped. Clause 2. The cases where return scrutiny proceeding have been completed and notices again issued using IIT Big Data software needs to be dropped to the extent of para which has already been covered in previous audits. I like to pause here.
I got it. Now you get now you come to the meat of the matter.
Now, Lordship, kindly see there's a
So
difference.
this is your case that there might be an erroneous issuance of notice
Which department states in their circular.
So for that, my proceeding that was concluded under section 65 should be taken note of, and no further for that year, no further proceedings under 73.
In my own case for 17-18, same case, department drops. I came to the writ court. The matter was pending. In the meantime, they dropped. I have attached dot Lordship, kindly takes the next page. I have attached the entire sequence, page 106 onwards. For the subsequent financial year. Lordship, 106 is the show cause they issued to me on 21/11/12/2023 for 18-19. Same attachment, Lordship, it goes up to page 118. 119 on 20th February 24. They issue an order for dropping the proceedings. Next page, Lordship, page 121, they give the reason. Page 121. Drop due to completion of audit under 65. 17-18. 18-19.
Okay, Mr.
Lordship,
Mr.
and I will have
Mr.
to.
We'll have your judge.
Lord.
Yes, Mr. Gogoi.
First of all, my lord, in the present, it is a show cause which is.
No, he has, let us counter his argument that 65, the proceedings were taken up for audit. So it's just an information given. You received the information from him, clarifications from him, and you dropped both the major deviations found. But because he had paid the tax late and interest was converted. So that 17-18 thing had got a closure. So now this output credit tax was also in the show cause now that you are claiming is output credit tax. These aspects were also noticed during the process of the audit. And you have come to a particular conclusion. Now, why that was ignored and the 73 proceeding was taken up?
That the ground taken by the petitioner, main ground. 1, 2. First issue in the instance.
So what is your material now?
One is short payment of GST. Second part is, my lord, regarding my. Also, we'll see in the next. For the first issue, we have categorically
Hmm.
stated, was discussed during the audit assessment. My lord, it cannot be said that, my lord, this particular so-called that we have issued, whatever issue involved in the present
Hmm.
was part of the, my lord,
Okay.
even if, my lord, the first part we can drop, my lord, the second part still remains. I say, my lord, so yes, the petitioner has got on, my lord, facts and figures. You can place.
So you mean to say that the second issue is regarding availment of input tax credit amounting to rupees so and so?
Yes.
This was not the part of the,
So-called has been issued.
this is not a part of the
Earlier proceeding of the audit.
audit proceedings.
These are, my lord, the different. We have
And
presented.
he has filed his GSTR 9. But why the projection in the show cause that the GSTR 9 is not there? Because GSTR 9 was reckoned both in the audit as well as in the attachment for tax determination. Ah.
An issue.
No, 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 no. You have.
That part.
That is the objection Mr. Khanduli has first pointed out. If we can come to that.
Page 46.
What we have stated. The same is.
Non-filer of GSTR 9. So your basic ground for issuance of the show cause or the summary thereof is wrong.
No, Lord.
Hmm.
On the contrary, that
This is attachment to determination of tax. This is an enclosure to the summary of the show cause notice. The summary of the show cause notice allegation is non-filing of GSTR 9. This is a determination tax. But the DCR 1, that is the summary of the show cause, right? So summary of the show cause says, what is the allegation? Non-filing of GSTR 9. So you yourself rely on that. So you're, okay, fine. No, we got it. We got it. But your projection in the summary of show cause, DRCR 1 is wrong.
filed annual return in.
This input tax credit comes in form 3 or form B? 2.
2A.
2A.
2A, Lordship. 1718, it was 2A.
2A.
In fact, the definition of audit, your Lordship says that encompasses input.
Mr. You are an expert in this.
No,
Let
no.
this court also try to understand.
I have.
On examination of the. Available in the office, it is found. Direct tax liability.
So this is your thing that a part thereof, first part is wrong, but the input tax credit form 2A, GSTR 2A was not correctly populated by him or populated by you, whatever it's there. Uploading was not there. So the show cause was required.
My lord, he can take every step now.
Okay.
Examine that.
So any other ground, Mr. Gogoi?
Penalty has been issued.
No penalty has been issued. Stoker. Is there a interim order from this court?
There's a stay of this.
Stay order.
We'll see again, my lord, 60 Roman 5.
Of the act. Okay. Page 67, Roman 5.
Roman.
Hmm.
Opponent says that there is no allegation that the petitioner has made admitted tax. Sign of the annual return. That it's out. The payment of rupees so and so. So
But this is something which was also taken note of in the 65 proceedings.
part of that particular proceeding.
It has to be when the total determination is being made or the audit is taking, it takes into account all those 2A, 2B, 2C, 3A. 3A is automatically filled up.
2A.
2A is
Based
automatically
on my supplier's returns,
returns.
2A is
2A is automatic.
First ground, that my lord. Or my lord, or any.
No, that to that extent, maybe I'm with you. But the thing is, if 65 has gone to the meat of the matter, which is now you are trying to raise in 73, that may be a bar. But then you will have to show how you have come to that conclusion. What is the reason to believe? What is the material you had? Because you have already closed it under 65. So that is you have given it a closure. Now, what made you to open it? You will have to see that. Okay. Yes, Mr. Gundlay.
that trade circular which I shown your lordship. That trade circular and my own case for the subsequent period, the department is taking a step by dropping it. Lordship, in this regard, two judgments, lordship. One of the Honorable Supreme Court in Radhaswamy Satsang, which says that though res judicata will not apply in case of tax laws, however, when there is no change in the procedure prescribed, then taking any other stand, department cannot take any other stand. And recently, lordships, the Honorable Allahabad Division Bench of the Honorable
Mr. Counsel, 65, that observations that was given to you,
lordships.
does it also have anything to do with the input tax?
Lordship, that is there in ADT 1. Kindly take lordship page 25. What records were submitted? And it encompasses my input tax credit also. Lordship, what happens, I'll tell you practically during an audit process, lordships, that I submit all the documents, my registers, everything. Now, that they bring out in audit observation only those discrepancies which they find, yes, these are discrepancies. Everything what they check will not come in audit memo, lordships. Lordship, may kindly take page 25.
I've got it. Now, how have they dealt with that part? Have they examined that part?
Lordship,
Or you say that that part not been included in page 27.
27.
So that was held to be correct.
Lordship, they say audit of accounts and records. So, lordship, accounts and records will encompass everything. I cannot pick and choose. The department today, lordship, audit separate commissioner is there. Audit commissioner will not pick and choose and only audit my output and not my input, lordships. In fact, lordship, during an audit, an extensive exercise is taken wherein all my purchase register along with copy of invoices is scrutinized. And this show cause which is there before your lordships today, it is based on data from software. They are taking, lordship, may kindly take the show cause ones. What they have taken in the show cause, lordships? Show cause, it's at page, the annexure to the show cause, lordships.
Attachment,
page 49. How they have determined this, lordships? Kindly appreciate this point. Excess claim of ITC. Page 49, my lordships, there. Under section 16(2)(c), every registered person shall be entitled to take credit of ITC on supply of goods or service to him, subject to condition that tax charge in respect of supply has been paid to the government. It is observed that the taxpayer has not correctly availed ITC under declaration of ineligible ITC. So the show cause goes with the deeming provision. It's an ineligible ITC without any finding, without any, it's a presumption. It is ineligible ITC. How they say? Kindly takes this table. It is seen from GSTR 9 and other information that they have claimed ITC on these commodities and therefore ITC claimed on this commodity or service is proposed to be recovered. This motor vehicle insurance, HSN code, lordship, these, when I file my input return 3B, these I cannot disclose. Now, how they are taking it in my GSTR 2A? Some vendors are showing returns. Inward supplies are coming. Those vendors category of registration, they are repair service provider. They are food suppliers. They take their vendors HSN codes and tell me, okay, you have availed this, so it is ineligible. Audit does a detailed exercise where they scrutinize my each and every tax invoice of input tax credit and they find it correct. Therefore, they do not raise any discrepancy. And
Okay.
basis software, they issue this. And my trade circular, Lordship, that trade
Okay.
circular.
Okay. Mr. Gogoi, when can you get your clarification on that? You can come online.
I-
You
Let-
did not
much-
give me a small note of your argument
I written notes.
along with the judgments.
Lordship, I will.
Just make a reference to that.
I will.
You have given
I
me.
will.
But Mr.
Take up.
A. Kanodia, learned counsel for the petitioner, also heard Mr. B. Gogoi, learned additional advocate general appearing for the state respondents. So, parties have been heard at length. However, Mr. Gogoi submits that he would receive further clarifications from the respondent authorities and make further submissions in the matter on the next date of listing. Full stop. Raised accordingly to list this matter again on 28 তারিখে board আছে না? 4 তারিখ? Time. 9 তারিখে নিম দিয়া। On 9/9/2025. That's awfully full the other days. That's the clearance is not
Some
coming.
preference may be given on that.
You can make a mention, no problem.
Lordship,
Or if it is,
down the board, then I will.
no, you can do one thing. We can fix it at 2 p.m. At
Get
2 p.m.
Much obliged, much obliged.
But I'll be grateful if you can give me the
Synopsis I will produce by.
tomorrow, day after, you can give it to
I will produce.
your.
I will produce. Much obliged. Grateful to you. Obliged.
39.
To item 9, Lordship will make a prayer for adjournment.
Why?
Senior to appearing in the part heard matter, Lordship.
A prayer is made on behalf of Mr. K. N. Chaudhary, Learned Senior Counsel, on the ground that he is presently engaged in another matter. He is presently engaged in another court. Full stop. Any objection? Your smile may mean many things, but I require an answer.
All my senior. They were suggesting 18th, Lord.
Sorry. Accordingly, registered to, not objected to by Mr. D. Senapati, Learned Counsel appearing for the respond number 2. Full stop. Registered not 2, 3. Registered to list this matter again on after in the week commencing from 15/9/2025 on a date to be fixed by it.
Like a Lordship, as on today, 2 whole. Then,
38,000
my lord, 479, my lord.
and
That is 49,000, my lord.
so the balance can he use?
My lord, the problem being that this 49,000 that they've kept a hold. On the same transaction,
We are sorry. We can't go beyond the banks.
my lords may kindly have page 132 for a while. 120,
Mr. Counsel, I can permit you to operate your bank account for all other amounts that are there, barring these 2 amounts.
My lord, but then the amount that they have frozen is arising of the same transaction which they have already demanded.
They
by
have
the
not
money.
got a clearance till now. Tomorrow there is a demand. Will you give him the,
My lord,
or how will the
But then
secure?
that transaction is pertain, that amount is
Okay.
pertaining to the same. transaction.
Mr. K. Das, Learned Counsel for the petitioner, for the Learned Standing Counsel, SBI submits that the petitioner can be permitted to operate his account maintained with the which branch?
SBI, Dispur.
With the Dispur branch of State Bank of India. However, two amounts, that is rupees 38,479 and 49,000, which have been identified to be proceeds of crime deposited in the account, be not permitted to be withdrawn, and a hold with regard in respect of the said two amounts be maintained. The above position is disputed by Mr. S. Mitra, learned counsel for the petitioner. Accordingly, the issue would now require a deep further consideration. Accordingly, admit the writ petition. Registrate to list this matter for hearing in the month of November on a date to be fixed by it.
1470. Direction of the Honorable.
That is your headache. Is there a stay order from this court?
There is a court order, my lord. That pays the.
No. Is there a stay order that you should not revert back that amount? Then why are you bringing me in there? Do whatever you want.
Plus, my lord.
नाम तो बोले वाले के लिए 9 and 10 এটা ইয়া করা সেপ্টেম্বর কো এরিয়া হিয়ারিং সেপ্টেম্বর
My lord, the respondents were to file an affidavit in the second writ petition, my lord. Order if your lordship sees of July.
Why the pleadings are not being completed here?
Cases, the first case or that means the second that is relevant because what will be decided therein will ultimately follow in the second case. Participate in tender process which ultimately culminated into a work order. And the ground of not participation is the discrepancies in the tender regarding the EMD amount. Because of the difference in EMD amount, he could not submit. So if that case is decided, probably the second case will not be able to
The question is
the
whether
second
they'll.
case is only the work order has been challenged there.
And the
Not in
minutes.
the first case.
And the minutes. But the question is, my lord, whether they'll file an affidavit. If you don't.
So my instruction is, I wrote to the authority. As of now, there is no instruction for the second case. Harping on the first case itself. The first case is at the behest of a person who has not participated in the tender process. Whether the entire nitty-gritties of the tender looked into, and that is a part of the
No,
second
that,
case.
my lord,
The
I'll
minutes
address.
and all those things as to how this tender process started. All these issues are there in the second case.
I'll address your lordship on
The
this
local
question.
arise from the first case. They have to first enter.
Now, my
the
lord, if they
process.
don't file it, my lord, let them say that they are not
Now,
filing it. Then,
My instruction is, as of now, Lordship, I do not have my instructions.
No, make a statement. When the second case you are not filing anything, we'll proceed to hear the matter. We'll record it. We can't have this matter coming daily for this purpose. You file, don't file, take a call. Okay. Mr. No records. Today we are hearing it.
in that event, my lord, I'll pray for some.
You are not pressing it. Okay. Mr. A. Sharma, learned counsel for the petitioner, for the respondent's number.
For respondents number 4, 5, 6, Lordship.
3, 4,
5 and 6.
in the second one,
732.
732. 3, 4. Assam Plain Tribes Development.
Plain Corporate
3, 4, 5,
6.
6. That is the tender issuing authority, right? Submits that no affidavit would be filed on behalf of the said respondents.
However,
In-
liberty is the-
Mr. I'm not stopping you. In WPC number 3234 2025. And you have filed an affidavit here
Yes.
in the second
and
case,
would rely on the affidavit so filed in WPC number 732 2025. Full stop. Mr. Sharma, however, submits that he would produce the original records of the matter on the date when the present writ petitions are taken up for final consideration. Full stop. The other respondents have also submitted that no further pleadings on their behalf would be brought on record. So, Mr. Chaudhary accordingly Mr. M.K. Chaudhary, learned senior counsel for the petitioner, accordingly submits that the present writ petitions be taken up for final consideration. As agreed to by the learned counsel for the parties, registry to list these matters again on whenever. Give me a date. After 6th, 7th, any date you can give. Please be comfortable.
11th?
11th. ठीक है sir? On 11/9/2025, on which date Mr. A. Sharma, learned counsel, appearing for the respondent Assam Plain Tribes Development Corporation shall produce the records in original. You are filing any writ? We had heard the
No,
explanation.
no, no.
Again, further explanation.
It's requirement. As they matter agreement to give me.
We'll hear it at 2. Duta Bazaar. Hope by the time Mr. Dhaka will also be free. 2 o'clock. Yes. Madam.
Timing 32 and 33.
Mr. Sarania,
Hello.
Mr. Chaudhary had examined the report and materials filed, and he is of the opinion that the non-application of mind by the SLC is evident. So, we were only having a problem with that clause 4 of the report, wherein he had said that some authority had said because your father married beyond the caste, so that cannot be a ground. So we'll interfere with that, remand back the matter for a fresh consideration by the state level scrutiny committee.
While challenging the, my lord, that impugn order SLC, there is no ground at all, my lord. That
No.
the
We are
grounds is coined by the court. my
Oh,
lord.
we
It is-
are interfering it on a technicality. So let it go back, because that's what Madhuri Patil and the subsequent line of judgments have said. Any dispute, go before the state level scrutiny committee. You appear. Board will be heard, and thereafter, in the manner prescribed, the authority will pass final orders.
File an affidavit then recording the records, my lord, what discloses that while passing the order, my lord.
You don't want a disposal. You want this matter to be.
No, my lord. Because, my lord, the order, my lord, has been cancelled. Still they are enjoying last 2 years, my lord. 3 years, my lord.
What?
Because
Agency.
my agency, my
That
lord.
agency will be continued to be utilized until a decision is arrived at in your favor.
But, my lord, in the writ petition, my lord, filed by the learned friend, my lord, there is no stay, my lord.
Okay, we'll hear.
And if there is no stay, my lord.
No, forget it. We tried to resolve the matter. Now we'll go for a detailed hearing.
Then take up to, my lord, the private respondent case, my lord, item number 32, my lord. Then
You are Mahendra Chauhan.
I'm Mahendra Swan.
Chauhan. You
My
make
part is okay.
your submissions.
My part is okay, my lord, because I am, my lord, only seeking direction from this honorable court to cancel the certificate, my lord, as per the SLC order and allot me, my lord.
Okay.
Direction to the.
Now come to the challenge in the present proceedings. Yours is WPC 6498.
My lord.
Hmm.
How, my lord, they have to, my lord, my lord, they have.
You
filed
forget
this case
them.
Challenging the.
You
impugn order.
forget them. You establish your challenge in the present proceedings. What is your prayer?
My lord. My prayer to my, they said as was the impugn letter of intent dated so my lord, proposing to award the Rajiv Gandhi Rural LPG distribution at Phauragari in favor of the private respondent, my lord. Then to satisfy the was the impugn letter of appointment dated so issued.
So you are challenging the engagement of the private respondent
My lord.
as an OBC
my lord,
for that retail outlet,
my lord.
right?
As he has been declared, he is not belong to
And
OBC.
you are making this on the basis of page 39, report of the
SLC, my lord.
SLC.
My lord.
Now justify this report. This is the only thing we'll have to look.
My lord.
If this is justified, then we will go. We are now ignoring Mr. Chaudhary's,
No, my lord. First thing-
whatever Mr. Chaudhary had put up, we are ignoring that. We'll go now strictly on the basis of the speaking order disclosures made. If it is satisfied, we will uphold it. If it is not satisfied, in the next case, we will reject it and maintain the OBC status.
My lord, that will be.
Yes, now you make your
My lord,
submissions.
that will be difficult because if first.
You
my-
have to
my
now,
case is based on that impugn order, my lord. So
okay, you
impugn order, they have
justify,
silence.
Mr. Sarunia, you justify this findings.
My lord, impugn order, I need not to justify.
Yes, you will have to,
Authorities-
Mr. Sarunia, you will have to because this is based on your complaint.
My lord,
Show me the basis of your complaint.
then my lord, come back. Only my prayer is that, my lord, they have to justify under what provision they have silenced the impugn order. On what ground? But there is a specific ground as per Madhuri Patil
But
case. my
before
lord.
that, the impugned order
My lord,
is on your complaint.
my lord,
So you were also there.
my lord.
So just justify these findings, that's all.
My justification is that as this my certificate has been cancelled,
Well,
by
let's,
the
let's,
impugn
let's
order,
come to
so
page
they're required to
39.
bear
Mr.
witness by-
Sarunia, for the benefit of the court, you
My-
can
my-
come to page
my lord,
39.
my lord.
The first paragraph is your complaint.
My lord,
Second paragraph is the, what do you call that? Needful that it has to look into.
my lord.
Third paragraph is a hearing wherein you were heard. Fourth paragraph is a report submitted by the deputy commissioner that he falls within OBC.
My lord.
And now the verification submitted by you. Can you have come to the fourth paragraph? 1, 2, 3, fourth paragraph.
My lord.
Can you read that?
The state levels,
Hmm.
state levels committee carefully examined all the above aspects
Hmm.
and seated several times to discuss the various.
No. Top portion 1, 2, 3, fourth paragraph.
My lord, whereas the deputy commissioner submitted his report stating that the Thubo Corel falls under the OBC category.
Hmm.
But the state level scrutiny committee verified the documents submitted by the complainant and considering the facts stated by the-
Document submitted by the complainant.
My lord.
Hmm.
Considering the fact stated by the president of Home Gurkha Sanmilan, Basra District Committee, the state level scrutiny committee found the following. The father of the Thubo Corel belonged to general category.
Hmm.
The voter list of 1965 reflected clearly as father's name was recorded as Tikaram Korel Sharma.
Hmm.
The name of the brother Thubo Korel was recorded at Mohan Prasad Korel Sharma
Hmm.
in the land document.
Hmm.
In the NRC data, the names of the brother of the Tikaram Korel, father of the Thubo Korel, was written as Lila Ballabh Korel Bamun. As stated by the respondent and president Assam Gurkha Sanmilan, Baskar District Committee, the caste status of the male degraded by the inter-caste marriage system to the lower caste.
Hmm.
As stated by the respondent, that is by the private respondent, my lord.
Hmm.
This president of the Assam Gurkha Sanmilan, Baskar District Committee, the caste status of male degraded by the inter-caste marriage system to the lower caste. That is the, my lord.
Now, from where did they get this documents number 1, 2, 3?
My lord. My lord, then I have to go to the reply to the affidavit filed in the second case, my lord.
The committee has, this is 4 is the statement of some President Assam Gurkha Sammelan.
That is by them, not by me, well.
Oh, but what is this 1, 2 and 3?
By two.
Where did they get these documents from?
Amar replied, Amar. Lordship may come to the my lord affidavit reply in the.
I'm holding that.
My lord.
Hmm. Paragraph?
my lord. Documents, my lord.
Hmm.
The annexure, my lord, for annexure 14, my lord. The continuation of the repetition, my lord. Page 103.
In the second case or in the, in your case or in his
In my
case?
case, my lord.
Okay.
In my case, affidavit in reply.
103.
103, my lord.
It starts.
Starts, my lord.
Relevant?
Relevant, my lord, this is the, my lord, NRC, my lord. Where, my lord, the grandfather has been, so, my lord, Lilla Vallabh Korel Bamun, my lord.
Where?
That is the NRC, my lord.
Page.
Page, internal page, I think 103, my lord. Maybe the first annexure,
Uh-huh.
my lord. This is the NRC, this.
It is 106. District Baska.
My lord, my lord,
Father name date Balkrishna Leela Vallabh Kodel Bamun.
my lord.
These are documents produced by you.
My lord.
Huh?
My lord.
Were these documents verified by the state level committee from the authorities? Because the deputy commissioner had given a contrary report.
My lord.
It was not verified.
Sir, my documents,
Is this the way, Mr.
Fine.
Sarania, under
Fine.
the Madhuri Patel's decision,
Fine.
the Supreme Court wanted the state level committee to go?
as per the paragraph 5, there is the inquiry to be made by my lord inquiry authority.
There has to be a field inquiry.
There 5, my lord.
Nobody writes their caste in their forehead. It has to be determined. And the word uses an anthropological study.
And
Where is that?
That is not challenged. That's why I'm saying, my lord. They have not challenged that they put what is the, my lord, illegality in passing the impugn order by the, my lord.
They have put the report to challenge,
No,
the decision to challenge.
In my, I have, my lord, said in my reply that there
There
is
is no
no
prayer.
ground of challenge, my lord. They have to put the ground, my lord. Why they have challenged?
Okay.
They are challenging that this is illegal without any ground, my lord.
Okay, fine.
There is no ground at all, my lord. They have
Fine.
that
We are
ground.
not closing your rights. Setting aside the order dated so-and-so of the state level scrutiny committee, that's a challenge here.
They have challenged, madam. What is the ground of challenge, madam? What is the illegality committed by the state level committee?
If we are strict to that extent, many repetitions may not survive the first day.
Courts cannot go into reviewing.
But we'll have to see whether the committee has acted in the manner it is required to act. It has not.
My lord, this is court observation. My line friend, there is no, not any set ground, my lord. That is petition, my
I'll
lord.
go to the root of the matter, Mr. Only thing is that we will remit this matter back. That is why we had required Mr. Chaudhary to go through, because he is neutral. Both of you, he is neutral. So we had required him to go through the records and give his opinion. He has given his view, which is also supported by, that's why I wanted to ask you, what is the justification in the order? Nothing. It has noted a few documents, noted the submission of the Gorkha Sammelan president, and then come to a conclusion. If that is there, why should we require a high body like them? Powerful. It's called a high power committee. Why any clerk can do that work here in the DC's office. Even the deputy commissioner is not required. There is
Yes, I understand, my
there
lord.
is a
I
need. The
understand.
Supreme
Only
Court
thing-
had done it so that a proper assessment is made and a genuine person is not left out. That's the underlying factor. So, we'll interfere with this. We'll ask Mr. We'll ask
There
Mr.
are other
Chakraborty also.
still, my lord, they have not done that, I understand, but where they have the silence, my lord, they have not.
Oh,
followed that.
Madhuri Patel is there. The sun is shining. You don't require a moon to deflect it back. The sun will take it directly.
When that specific line is there, my lord, at least they have the what ground they have, sir. So I have taken specific stand, my lord.
Yes,
in
Mr.
my-
Chakraborty. A very serious allegation against you. Very serious allegation against you. You are a bamun and you are masquerading like a. This is not done.
Also wear a thread, Lord.
No, I know. This is just a thing. We know that.
Wear a thread.
We know that. We know that. Only the number of the, it's different. What was the materials? Yes, Mr. Chaudhary.
A chance. Petition stated that
I filed a
but he
complaint.
did not raise any complaint till then. Waited for the draw. After that, he raised.
No, no, same day I made a complaint.
See, Mr. The only anxiety of this court is if you are not an OBC, then you are depriving a chance of an OBC. Genuine candidate, only thing that we have to satisfy ourselves, nothing else. Yes, Mr. Chaudhary.
Corporation is sponsor.
No, you're not here as a counsel for that. That only we'll record in the order. But what do you find from the records?
The records, my lord, they-
Nothing was done.
April 1975, considered, and then my lord, the finding as you know.
Nothing is there. And there is nothing about field verification. If we hold the report of the DC as the field verification, it goes contrary. And it has not been dealt with in the report, in the, what do you call that? Go back within a particular period. And the appointment of Mr. Chakraborty would be subject to the final decision of, if the SLC goes against him further after the detailed exercise, go. If Mr. Sarania is entitled, he will be considered. If he is entitled. If that process is there, he will be considered, or if it is put to further notice, then he will also come in. That's it. We can close it, Mr. Sarania. We'll give a time frame. What would be the ideal time frame according to you? This, if we maintain this order, it will be doing injustice in another case also, because that will become the law. Should not be.
My lord, court can make a
I'll put my reasons for that.
challenging those, my lord.
And you can start preparing the appeal if required. Because the law should be settled in,
After the committee,
I'll put for that.
That
I'll-
is my prayer, decision not cancel the certificate. That I have made clear in my.
No, because that is now under challenge. So we'll not go into that technicality. We are going into the root of the matter. But the parties at length raised it to list this matter again on 4/11/2025 for delivery of orders. It Madhuri Patel or judgment to Aru Homaulelo. Mug didle hol.
My lord, the period will be not more than 3 months, my lord.
What would be the period? 3 months, maybe it's enough.
Not more than that.
3 months would be enough from the date of receipt of the certified copy. Okay. Hey, party naam kita sab le lo. Yes.
Kindly have page 130.
No. We'll have 135.
Yes.
Whether that is satisfying.
It's a light vehicle. Tata double cab pickup. He himself admits that in his affidavit.
It's not a heavy vehicle. It doesn't correspond to the amended.
Because it's a bus, 48-seater bus is the requirement. That is the case.
I missed one thing, Your Lordship.
para 8 of my petition.
A better one.
Page 147. Para 8.
Mr. Counsel, Mr. Gogoi,
Yes.
it is not your heavy duty license, heavy vehicle license that is required. Whether the vehicle that was used for the contract is a heavy vehicle or a light vehicle.
Pickup.
On after
Pickup, that small.
Okay.
on 8/3/22, they have given a mail to the petitioner. In this regard, we have stated that in para 8, I will read.
Hmm.
Page 9. That the petitioner on receipt of the said mail submitted his experience certificate on 8/3/22, providing the details and required documents of providing heavy vehicles to the Respondent Corporation itself in the form of 12 KL capacity tankers for transportation of crude oil to various field locations of the Respondent Corporation for a period of 3 years from Mr. MS Lexon Engineering, which also was certified by the said Lexon Engineering.
So this is the one you are referring to in para page 353, right?
So this is another one. After receipt of the mail.
No. Where have you justified the 39.45 heavy vehicle use revenue?
Then in the document.
You have taken me to 353
Yes, sir.
first. Huh?
That pertains to that vehicle. The bill pertains to that vehicle at page 360. Page 350, the first line. The vehicle. You
Tata, because in the earlier tender, it is not of the similar work does not.
Mr. Gogoi, we are not to that now. Whether you satisfy page 35 or not. This you have shown in satisfaction of page 35. Right?
Yes.
Mr. Sharma on instruction submits that this is not satisfactory because this is a light vehicle. Of the reply itself.
Page 345. Page prior to this. Page 4. Lordship will come. So the safe vehicle did not conform to the requirements of the heavy vehicle.
Why this sort of a statement, Mr. Gogoi? What is the purport of this statement?
It does not, however, meet the requirement of a heavy vehicle.
So this is gone.
But I meet that particular amount of 30.
Fine, what you need is your need. We are not coming in the way. We are only trying to examine whether the petitioner satisfied that and he was illegally kept out.
I have explained. So
We'll have it at 2, Mr. Gogoi. Just recapitulate your thought process and come back. I only want what is your satisfaction with regard to page 35, and I'll not hear that after corrigendum heavy was brought in. That may be not open to you. We will go by 35 as it is. Just demonstrate before this court that prior to 14/12/2021, in satisfaction of page 35, you have received 39.45.
the explanation was given in the here. Though at the time, page 346. Though the said vehicles did not conform to the requirement of heavy vehicle, it may pertain to mention here at that relevant point of time when the petitioner submitted his bid, the requirement of other vehicle in the.
That we will not accept it. We will not accept it because it underwent a change before the last date had come in. It is a different matter. You had submitted your bids. Thereafter, the oil authorities gave you an opportunity. Give us materials to show that you have 39.45 by heavy vehicle.
Yes, we have submitted.
And he
this-
submitted. So he
in my-
surrendered himself to that amendment.
In para 8, page 9, and annexer 147.
Page
And page 145, so it starts. of petition.
145 of the writ petition.
Yes, sir.
145.
The type copy 11%, page 147. Certified at MS Lixon Engineering Station Road. PO
Where? Self-declaration.
Last portion, because contract number and the vehicle number is recorded.
No, 45 is a mail.
145 is the mail between the parties. 147 is the declaration given by the election.
Self-declaration.
Yes.
Okay,
It
great.
is certified at MS Lexington Engineering Station Road, PO.
Where is that? Where is that certified that?
147, page 147.
Self-declaration.
Here the work is.
No. Is it a self-declaration?
Yes.
Signed by him. Next page.
Name of the bidder Rimpumoni Bodloy.
Yes. It's in
This one.
Yes.
Yes.
Where are you reading?
Page 147.
It starts with self-declaration reference clause 2.1.15 or BEC, BRC. Just show me the document. In your writ petition, it is there.
Yes.
Okay. Okay.
Certified at MS Lexington Engineering Station Road, PO Division, so was awarded for following contract by MS Oil India Limited, which has been completed as per terms and conditions of the contract number so. Description of hiring of service of 12 KL capacity browsers tankers for transportation of crude oil condensate from various oils field location in Assam, filed for a period of 2 years with a provision of extension by another 1 year. Date of commencement 4/6/13, date of completion 3/6/2016. Total value of the work is 2,50,93,832. I have given my vehicle.
Where did your vehicle earn 39.45? That's the case.
This actual is a contract of a different bidder where he gave one bus.
Bus. And that bus is permissible.
Yes, permissible.
But he will have to earn from that one bus 39.45.
He earned 20 lakhs. Which is in my affidavit I have stated. And I
that we
have
have-
now also the evaluation with me. The bus that he gave has
Earned
none-
20 lakhs. So you rejected him. Now then we ask Mr. Gugoi that is there any other work wherein you have earned 39 point? Then he refers to that 43 lakhs thing. But the 43 lakhs thing according to you is not heavy, but it is light.
And according to his admission in his
It's a, yes. You recapitulate your thoughts. Maybe this was not expected. We come back at 2. We'll hear you.
You also be taken on Monday.
No, I'll forget.
Because I have to take instruction.
Small memory, so much things. Just think over it. Find out a document which shows 39.45 from one work. I am with you. Otherwise, I'm going to dismiss the resolution.
Oblige.
Oblige you last.
দুটা বজাতে মাতি দিব। Yes, Mr. Kumar, after a long time.
Better late than never.
Oh,
My lord, here on a last order, your lordship will see, there is a categorical statement from the state of Arunachal that the area falls within their jurisdiction. And in spite of that, my lord, the Assam government has not filed the affidavit. They says my vehicle, they don't allow me to do my business. How I will survive, my lord, in this? Without
we'll
my-
see how you survive. But today the matter is that respondent number 11.
Your order, lordship will see the last order dated 23/7/2025.
TC Ranjit Ram, Divisional Forest Officer, North Kamrup Division. He has been served. Yes, Mr. Bhattakur. Oh, by tomorrow?
My lord, the 2 weeks will be too long. My lord, my learned friend will have his, but we can have it next week, my lord. Weeks will
Uh,
be-
seen
Thursday
the,
next,
seen the order of the Lavazima court dated 28/2025. Also, a perusal of the said order reveals that the service of notice upon the respond number 10 and respond number 11 has been completed. Also, accordingly, the present writ petition is required to be listed for admissions. Listed under the admission column. Full stop. Is required to be taken up for admission, hearing. Full stop. Mr. I. Borthaku, Learned Counsel for the Learned Standing Counsel Forest Department submits that the affidavit that the instructions have been received and the affidavit in the matter on behalf of the respondents represented by him would be filed on or before 1/9/2025. You are filing, Mr. Arun, anything? Mr. A. Chandran, Learned Senior Government Advocate, appearing for the state of Arunachal Pradesh, also submits that the affidavit would, on behalf of the respondents represented by him, would be filed on or before 1/9/2025. But stick to that date, both of you. The petitioner is at liberty thereafter to file his, bring on record his rejoinder to the affidavits that would be brought on record by the respondents on or before.
it may direct to be listed on 4th if necessary. We'll file it within 24 hours.
No. On or before 5/9/2025, if so advised. Raised it to list those matters again on Nori. On 11/9/2020.
12, my lord, 11, no, oh, sorry.
12th, we'll have to hold a special court then.
Oh,
We'll
sorry,
have it
sorry,
on
hold it
15.
on. Nine,
15.
nine.
9, Pari, 9 Nori.
Small matter.
Pari, okay. 9.
Deeply obliged.
Forty-three,
Itu kilo. Itu. Yes.
Compulsory requirement
Ah.
mechanism.
Today you are ready with all the ammunition.
No ammunition.
Shoot.
No ammunition. Only मतलब that Assam State Financial Corporation Act 46B and 48. Let me
State Financial Corporation Act. You are referring to State Financial Corporation Act.
1951.
I know.
Controversy is मतलब that they don't adopt. They said they don't adopt this state policy for compassionate appointment. At the same time, paragraph 8, मतलब they say that they are statutory authority. Paragraph 9.
Dr. Sharma, give me your points. Give me your points. Give me your submissions. Point wise. First one
First one is मतलब paragraph 8.
of the AIO by the corporation.
Corporation, my lord. They say that Assam Financial Corporation is a statutory organization constituted under Assam State Financial Corporation Act 1951. And same paragraph, they say that policy is not applicable. A corporation. In the subsequent paragraph, paragraph 9, they say that Assam Financial Corporation is not a government institution and the government policies are not applicable.
Mr. Sharma, nowadays you don't feel hungry in the afternoon.
Yes, I feel like it.
Everybody is getting hungry. Mr. You're waiting for calling. Oh, that matter.
Yes, Lordship.
Okay, we'll have it in the second half. You are here today. The opposite counsel was not there. She's here. Fine. Mr. Sharma, we'll have it at 2. Gogoi.
The time of filing the bid, the clause, any other transport services. That time,
That is gone.
at that time, because
That is gone.
we have submitted a bid, after that they have changed it.
Hmm.
And your lordship may see the clause 4.2. So you should look not before the bid, not
Now-
after the bid.
Now that, see, they are empowered under the tender conditions also to alter before the last date. And they have altered within that. It's a different issue that you submitted your bid before that. But they can't be bound by that. Because they have already modified that tender conditions. They gave you an opportunity. Let's see, if you have this criteria, kindly furnish the details to us. You have furnished the details of whatever criteria you have. Now you can't go and ask them to go and evaluate your bid with regard to the unamended criteria. Because that amendment took place in course during the pendency of that tender conditions. So we'll have to allow that much liberty to them. That's why I said, if you have 39.45 in terms of the amended criteria, show that, we will direct them.
But not heavy transport, but
We'll record that. I can't help it now, Mr. Gogoi.
for 4.2, you see, clause of 4.2, page 23.
Hmm. 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 Hmm.
4 point last, bidders are to check from time to time the e-tender portal, technical RFX, under the tab amendment to tender document for any amendments to the bid before submission of their bids.
So, Mr.
So,
I'll try to have further clarification from you.
And
Where is that schedule for submission of bids?
they also admitted in their affidavit,
From when was the bids open for submission? When were the bids open for submission?
Actually, it
Oh.
was page 17,
7017.
17.
Okay. Hmm.
The bid closing date and time was 14/12/2021.
Hmm. Hmm.
Amendment came page 1 on 10/12/2021. And we had therefore revised page 1.
No, when was it open for bids being submitted?
133, revised bid opening date.
No,
and
no, I
time,
got it.
21/12,
That is the date
21/12.
of closing and opening. So when were the bidders eligible to submit their bids? From which date? What is the date of the bid tender? When was this issued?
it was issued on 23/11/2021.
23/11.
2021. I submitted it on 1/12/21.
Just a moment. There was no pre-bid meeting. There was no pre-bid meeting here. So the forms, the tender forms were available for being bought from when? From 23/11/21 itself. Normally you give those dates.
This tender, otherwise,
And you submitted your bid on?
1/12/21.
at any time prior to deadline.
Deadline.
Submission of bids. Deadline for submission of bids. Irrespective of when a bidder. And was at page 27 provides us the power This is the contract, tender to extend.
No, that when read with the conditions which you have set out in amendment of the bid document, section 4, you can amend the conditions of the tender. But before the last date fixed. And if required, then you can extend the deadline.
It on therefore 10/12. The amendment came on 10/12. The
10.
last date was 14/12. 2 days prior to the last date, the amendment came in, and therein we revised the date of opening, submission and opening. Gave them a chance, furnish additional documents.
That after the date of your closing of the tender, that is after 21, you offered them an opportunity to.
Phase 1, which he responded by submitting. So
Mr. Kulta, can you just give me a list of dates with all these dates? You can leave it with her on Tuesday. Mr. Gogoi, show me one tender that you have completed. Rest I'll take care. Not there. And I can't permit you to go back now and challenge the tender, corrigendum or the tender conditions after the last date.
Going to be silence.
I know that. I can't permit you to do that because you have been given an opportunity and you acted. You submitted. Because even if you were not a bidder within the 4 corners of the terms and conditions set out with the corrigendum in the bidder, they gave you an opportunity to come in. You have not been able to satisfy that. So we cannot permit you to now come in. Unfortunately, you have missed the bus while giving a bus.
So they have admitted in their affidavit that although the petitioner has the experience for similar service.
I know,
Yeah,
but you don't satisfy the 39.45.
Actually, I was selected as here, but we have not supplied the copy of this registration order.
he was always there.
Because he has-
Just produced
because-
this evaluation.
She has not annexed it
Anyways.
with the affidavit of position.
Got it now. I can give you.
Where is that email you gave him? Page 1?
If the pagination is correct, Lordship.
No, there are 2 petitions here. There is the unamended petition,
Amended petition.
143.
143. Just state the annexer
Annexure 6.
and his response. 44. Email dated 8th of March. Ask them. When?
Must.
Bowser that he has given to that election of the All India, but the amount that that particular Bowser earned was 20. Ripumoni. Details are there thereafter.
So it's basically 2.11 not being satisfied to the extent of 39.45.
Will that be heavy vehicles?
And that earlier one will not be, he has himself said that in the repetitive.
That is why he was rightfully rejected. Committee.
But Mr. S.R. Gogoi, Learned Counsel for the petition, and Mr. A. Sharma, Learned Standing Counsel, Oil India Limited for the respondents. 1 and 2. Mr. H. Sharma, Learned Counsel appears for the respondent number. You are basically on the same page. Same page. Course of hearing concluded. Registry to list this matter again on 3/9/2024-25 for delivery of orders. Mr. Gogoi, I'm still giving you an opportunity. If you have already from some material you might have missed out, there is something, give me a small note before the next date of listening. But don't reiterate that the earlier thing will have to be followed. That I'm not accepting. No, NIT means that after the email given to you.
T3.
Yes, Mr. Sharma.
Writing. Be in writing also by tomorrow.
I'll take the dictation. You give me. But Mr. S. Sharma, Learned Counsel, I'm just going, you just give me in the meantime the facts. Heard Mr. S. Sharma, Learned Counsel for the petitioner. Also heard Mr. C.K. Sharma Borwa, Learned Counsel appearing for the respondent number 1. Who is there for 2, 3, 4 and 5? 1 and 5. They are so confident, 2, 3, 4. They don't want a representation also. 2, 2. 1 is finance. So you're for 5. Okay. Look it up. Mr. S. Sharma, just submission. Mr. S. Sharma, Learned Counsel for the petitioner. After reiterating the facts noticed herein above, has submitted that the father of the petitioner at the time of his demise was working as a messenger in the Assam State Financial Corporation. Also, the Assam State Financial Corporation being a creature under the State Financial Corporation Act 1951, it is to be deemed to be a state within the meaning of Article 12 of the Constitution of India. Also, he submits that the provisions of Section 39 of the Act of 1951, the state has full control over the Assam Financial Corporation and its policies and its power to make policies. He submits that the compassionate appointment scheme being a policy framed by the state of Assam, the same would automatically apply to all its constituents, including the Assam Financial Corporation. Also, in the above view of the matter, Mr. Sharma has submitted that the policy being available, the non-consideration of the case of the petitioner for appointment on compassionate grounds had caused a prejudice to the family members of the petitioner, and accordingly, this court would now be required to remedy the matter by directing the respondent corporation to consider the case of the petitioner for appointment against any vacant post available in the establishment. Anything more?
Alternatively, they could have sent my application to the respondent number 1, because respondent number 1 is.
He
the
further submits that the corporation being a creature of the state, the respondent authorities in the event were not having a scheme for appointment on compassionate grounds, and the scheme, and if it is assumed that the scheme of the state government is not automatically applicable to the Assam Financial Corporation, the respondent authorities of the authorities of the corporation, authorities of the corporation ought to have forwarded the application of the application of the petitioner to the respondent number 1, that is the Department of Finance, Government of Assam, for further consideration. Then, this much. Hearing. এইখিনি খালি মাৰি দিলে মই সোমাই দিম বাকীখিনি বহি দিবি দিয়া writ petition dismissed. Sorry.
53.
We have filed already.
Yes. How long will you take, Mr. Bhattakur? Half an hour. We'll finish it up at 10 minutes. What is your point? 10 minutes, possible. Mr. Bhattakur is there, 5 minutes he'll take. I'm giving you 5 minutes more. Bonus 5 minutes.
I'm not so genius, my lord.
You are a genius. Half an hour is only for the purpose of confusing this court.
No, my lord.
To make this court understand, you will take 10 minutes. Oh, we'll go back to that page. Where is that page? Where is that calculation sheet?
Let's see, my lord. What is the
173. Yes.
before that, my lord?
We are with 173, Mr. Bhattakur. That is given by Mr. Roy, the employer. We'll not go beyond this. Now explain 173.
Quantities, my lord.
Forget the bill of
Yes,
quantity.
it is the cash order matter, my lord.
Mr. Bhattakur, first clear this one. I'll have to write the judgment. You clear 173. To mic sound na hai ki hoise sabo lagbe to online sound na see it's on or not.
My lord.
Yes. A mic to side out ase to etu kan ei phale thakile nahi. Yes.
The EPF contribution, my lord. Daily limit is 15,000, my lord. Per month, my lord. Is the wages is 655 as per
Per day. Hmm.
But it is 65,
Hmm.
though it is 26 days, but it's for the whole month, my lord.
So
Inclusive,
forget the rest part. Now, if an employer has to pay out a PF dues for an employee concerned for the whole month,
whole month.
he will have to multiply 655 by 30. Because for that 4 days of rest also he is paid a wage. So 30, you get an amount. Now that amount being higher than the minimum ceiling, 15,000. So we fall back on 15,000. Now 15,000, if it is the monthly wage, you divide it by not by 26 but by 30. Finished. That is the end of the game.
This is our case, my lord.
Yes. I'll do that only.
The authority, my lord.
If you are multiplying it by 26, you have to divide it by 26. If you are multiplying it by 30, you will have to multiply it, divide it by 30. Because why I'm saying so,
655.
you cannot go beyond that minimum wages
Yes.
of the per day.
Yes.
You cannot go beyond the minimum wages. So if you can't go beyond the minimum wages, that is why you don't divide it by 30. You divide it by 26.
No, my lord. No. No.
Satisfy me.
Yes, my lord.
Hmm.
Yes, my lord, the kindly see the EPF Act, my lord.
Hmm.
First of all.
EPF Act to Diyasan.
The EPF, my lord, and the
EPF, insurance, EPF, Provident Fund.
the EPF and the ESI, my lord. What will be
We'll
the-
take up EPF first.
Yes, ma'am.
Hmm.
What will be the, my lord, minimum wages? That is not defined. It says, my lord, basic wages.
We'll have to go to the Minimum Wages Act for that.
No, no, my lord. In some cases, my lord, that's why, my lord,
Yes, which is the provision you want to? Scheme.
to be, my lord, basic wage.
Section 2, subsection basic wages, huh?
Wage means emoluments which are earned by an employee or on leave or on holidays. Rest day also. The 4 days has been given, my lord. The wages in either cases in accordance with the terms of the contract of employment and the which are paid.
So, Mr. Bhattagur, so you have 655. Now, to arrive at the monthly wages, how will you arrive at from 655 to a monthly wage? How will you, what is your take?
26
Multiply into 26. So you have around 17,000 odd.
is 15,000.
Huh? Now,
Says, my
from
lord,
I told you, no, this is that old chip. So it takes some time to register. So now reverse way out. You have arrived at 17,000. I say find out the wage per day. How will you do that? We have arrived at 17,000. Now find out the wage per day. How will you arrive?
If we divide it by 30, my lord.
Whatever you say, you want me to divide it by 30, I'll have it by 30. What will be the wage that come out?
But that-
Multiply.
But that-
Mr. Bhattakur, we are trying to understand. You multiply. 655 into 15 is how much? I remember my father saying you should run your maths very nicely. Today I'm 17?
567.66.
No. 17,000. 655 into 26 is how much? 17,030. So forget now 655. We have 17,030. Now a situation has arisen. I want you to find out the minimum wage for a day. If the monthly salary is 17,030, how will you find it?
Yes.
How will you find
Yes,
it out?
now the acts will help us.
Forget the act. Forget the act. Give me a straight answer. How will you find out if it is 1730, your monthly wage, forget we don't have, the tender does not have a condition of a minimum wage per day. It says minimum wage for a month is 1730. Now, how will you find out the wage for a day? Divide by 26. Are you sure for that? So you get 655. Now, what is the basis for this? That you cannot go beyond the minimum wages. Now, what is your take? Now your take, because it will be around 500 something if we divide 1730 by 30. Okay, what is your take now? How do you make this calculation? He wants to try again to satisfy me. I'm giving him an opportunity. Yes.
Rule 29.
No, I'll come to Rule 29. You give me the figures first. How you interpret it should be. We have 655. Now, to apply 12%, I'll have to have a monthly wage. Mr. Bhattakur. So, the monthly wage on which I will apply the PF is 1730. Right? 12.5 plus 1%, forget 1%, 12%. And I'll give you, pay out the money. Now, if I have to divide it by 30, forget the minimum ceiling part for a moment. If I have to divide it by 30, which is your projection, into 26 we get 1730. Now to get the monthly wage for the purpose of PF, you divide it by 30. Now divide 17,030 by 30. 567. Okay, that is your game. So you as an employer will now be doling out or making a deposit of the PF amount at 570.
Days, my lord. This is choose the 4 days. There is is called my lord raise day, my lord.
So the 655 minimum wage, 655 is payable for 30 days.
Yes.
Or 26 days.
30 days, but as per the act, it should be 26.
26 days by Mr. Bhattakur is the days he actually works. But if you are dividing it by 30, after multiplying the minimum wage by 26, you arrive at a minimum wage which is below, amount which is below the minimum wage. How can you fix it? You are making an illegal gain. At the same time, the employee is also giving out at a lower rate PF amount. Show me, demonstrate. That's the only thing I want. Huh?
Rule 29, my lord.
Of scheme. Okay, 29. Let's go to 29.
29 5 provision, my lord.
Contribution. The contributions payable by the employer under this scheme shall be at the rate of 10%. So and so, so and so, so and so. Ours is by the proviso. This case is by the proviso. Provided that the above rate of contribution shall be 12% in respect of any establishment or class of establishment with so and so, so and so. Now you come back to 20. Subclause 3. Contribution shall be calculated on the basic wages, dearness allowance, actually drawn during the whole month, whether paid on daily, weekly, fortnightly or monthly basis. Now you show me that your employee will not draw the money for 4 days in a month.
Why? My lord, the 4 days is given, my lord.
But the
Being an employer.
okay, that is what.
Being an employer, my lord.
So let's say A, B, and C are employed. So A works for 5 days in a week, 6 days in a week, 7th day B comes in. Huh? Now for the 7th day, A does not get any payment. Then that is the end of the matter. Yes, Mr. Dekar.
Simple logic, my lord. If you are dividing by 30, you have to multiply by 30.
If you're dividing by, multiplying by 26, you divide by 26. Sure, show me. I'll bear with you for the whole day. I'll tell Mr. Kohli, sorry, and I'll bear with you for the whole day. But if it comes out something else, then you will have to compensate the loss of time also. Mr. Bothakur, come back to 29, 1. Read that carefully. Okay. Contribution payable by the employer under the scheme shall be at the rate of so and so and retain payable to each employee to whom the scheme applies. Now you come to 3. Contribution shall be calculated. Actually drawn during the whole month, whether paid on daily, weekly, fortnightly or monthly basis. So actual drawal is 655 into 30, not 655 into 26. We are not concerned with any other issue. We are concerned with a tender and the assignment of value of the PF component. That's what I'm saying. You cannot ignore that period.
12 whole month,
Hmm.
including the 30 days, my lord,
Hmm.
not for 26 days.
Then you multiply the thing by 30, divide it by 30, finished. Comes to
No,
650.
but the minimum wages of X says, my lord, is I have to.
Let's go. Let's understand. Minimum wages. Yes. 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 Where? Which section? Hmm. 23. Hmm. Hmm.
Employee.
Hmm.
Shall be paid wages for the day's day. By dividing the daily rate of wages of employee. Daily rate of not wages of employee, not for the day's day salary. Equal to the wages rate at the overtime rate.
Mr. Bothakur, come back to clause 4 of 23. Sub rule 4 of 23.
Wages.
Hmm.
Equal to the next
And the rest is not required for us. So the Sunday will be the wage that he'll get on Monday.
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 He will get the.
Now you come to the proviso.
Then.
Stop there. Provided that where the minimum daily rate of wages of the employee as noticed under the Act has been worked out by dividing the minimum monthly rate of wages by 26. Now, when there is a case that the monthly rate is fixed, you want to find out the minimum wage, you will have to divide it by 26. Same way, when you are finding out the total wages from the daily wage, you again multiply by 26. There cannot be anything. So 15,000 now finished.
No, madam,
Yes, yes, we have got it. 15,000 is the monthly wage.
Yes, madam.
15,000 is a Mr. Forget it. Minimum Wages Act provides first proviso to clause sub rule 4. 15,000 is the minimum wage.
Yes, this is.
Divide it by 26 to find out the minimum, the daily wage. That's the end of the matter.
But the X says, and
Reserve your energy for the next level.
পরে মোহাম্মদ কালনি সি মানে yes
Next level, next level.
5 minutes মানে yes I মানে কালনি
So we have finished it 5 minutes, another
Yes,
5
yes.
minutes. Okay, I told you 10 minutes. Okay, then. Yes, yes. Have you quoted these provisions in your?
I have also given the calculation, my lord.
But I don't want a calculation. I
Over
want
the
a
period of 4 years, how much will be the difference?
difference. Yes. Which? Yes, Mr. Botagot.
39 madam
39. Okay.
plus 4 madam contribution payable in respect of a SPR shall ordinarily as day of the SPR.
Here we have got no problem because their wages are below 21,000.
Yes.
We have no problem. The problem is with PF.
No madam,
Both.
on his document I'll
Okay. Anything more?
madam
42.
my lord.
Oh, Mr. Pothakur, this is pertaining to a beneficial provision given to the employee that he did not make any contribution if his wages is minimum, below the minimum. I'll see anything, but show me the meat of the matter. Maternity benefit. Mr. Pothakur,
Please, mama, I'm reading madam.
read.
Base limit of the coverage of an employee under month, my lord. I have to pay for 26 days, my lord. The whole case is this, my lord.
Fine, I understood. Got it. We'll appreciate that. We'll pass our orders, appreciating your contention.
One issue also, my lord. When then, my lord, I know.
If you knew, if you presume, how can I help? I'm only hearing. I've not decided. I'm trying to understand.
I tried to, my lord, tried to express, my lord.
Mr. Pothakur, I think we have heard you enough.
There are just four clauses, items, my lord. 5 items, my lord. Where, my lord, is not.
I'm giving you an opportunity. I'm not passing the order today. You give me a written argument. Bring it in seriatim, all these aspects.
One page, my lord.
Yes. Yes, which page?
187, my lord, kindly see, my lord.
Why? Page?
187 of the
Ah,
benchmark, my lord.
the BOQ, huh?
My lord, kindly see the number 3. Benchmark. What he quoted, my lord.
Where are you?
187.
Hmm.
6.2.
Ah,
My lord, against the, my lord, what he quoted, my lord.
$8,65,000.
The benchmark, my lord. Now he quoted below, my lord.
That was because of an error in the calculation of the railways. BOQ calculation was erroneous.
No, my lord.
He is trying to show that in the tender, I was required to quote
Estimated
in a particular branch, I have quoted below, my lord.
Hmm.
But my tender has not been rejected by the railways
on that count.
on that count.
That he will have to suffer.
Then, my lord, he
My lord,
become a-
kindly come to 186, my lord, 6.1.
Hmm.
What does it say? The financial tabulation statement, Lordship has got it.
Hmm.
Financial tabulation statement with detailed breakup downloaded from so for technically qualified bidders. And finally, my lord, when the L1 is arrived at page 188, my lord.
Hmm.
6.2.1, discussion on compliance of total minimum wages. It is the total minimum wages. And at the point just above 6.2.2, from the above tabulation, it is found that all the bidders have quoted above the total minimum wages required.
minimum wage, my lord, if you have any, yes.
Okay. When are you giving me the note? Tuesday. Wednesday. Okay. Lekha. Hearing, heard the parties at length, hearing concluded. The counsel for the petitioner has brought on record his written argument. So, Mr. S. Bhattakur and Mr. S.S. Roy, learned counsel appearing for the Mr. S.S. Roy, learned CGC, and Mr. S. Bhattakur, learned counsel appearing for the respondents have prayed that they be granted time till Wednesday, date to deliver for no. You can hand it over to Mr. the bench president on 26th. On 20 submits that they will bring on record their respective written arguments on 27/8/2025. Register to list this matter on 29/8/2025 for delivery of orders.
This aspect of the matter, the last submission, I have not dealt with in my written arguments.
But clarifications.
Give it together. Give it together.
Oblige me.
A copy was given to him. You have factored that?
Yes, yes.
Done.
Yes. I had got 2 copies. My learned friend has taken 1 copy. I'll make a photo.
Back one more copy.
He's
Join
taken
the
1
matter, I
copy.
said I want to read it.
Mr.
I'll make a
Kohli was roped in, so I'm not making any comments. Otherwise, I would have given my comment.
I'll make a photocopy and I'll hand over, madam. All right.
Mr. Roy, have a cup of tea also with him. 40?
Lordship, this matter may pass over for timing, Lordship. In council, Digos is engaged in court number.
Oh, that promotion matter. Double promotion.
Maybe with my senior Lordship.
Okay, time being. But after the end of the list. We are disposing it today. Yes. Yes. Hmm. That correction was permitted. 226 to 227. Yes, madam. 7. Ah, he is here.
Sir,
Yes. Yes, Mr. Hawk.
Petitioner matter before you lost matter. Mainly agree matter at the matter. But out of the respondent matter
You rectify this. Rectify this. This cannot be under 226. It has to be 227 only,
yes, yes,
right?
yes.
So rectify it. Then come back, we'll see. We would love to have we'd love to have you before us. Why should we? Fine, be here. We may require you sometimes. Heard Mr. S. Hawk, Learned Counsel for the petitioner. Also heard Mr. A. Das, Learned Counsel for the respondent number 1, and Mr. N.C. Das, Learned Senior Counsel, assisted by Ms. J. Bush, Learned Counsel, appearing for the Power Grid Corporation of Northeast Transmission, Messrs. Northeast Transmission Company Limited. That is the respondent number 2. Also heard Mr. N. Das, Learned Advocate, appearing for the state respondents. Baki, 2, 3. Four, 5, 6. 3 years. Para 2, para 3, para 4, para 5, para 6. Same order here. Registry to list this matter again on para 7. After 2 weeks on a date to be fixed by. You rectify it. You need not be very worried. We have not dismissed your petition. That is kept for the next day. At last.
Yes, Lordship, at last. There is a house by that name. I have seen it before in my childhood. We had Lordship EPDP colony, East Pakistan Displaced Persons, those who came after
Colony, Delhi.
71. So there was a house on which the gentleman had written, he was Bhattacharya, at last.
We have a road here in the city. It's called Terminal Road.
Lordship Terminal may not be at last.
Because it does not, there is no out
Lordship Terminal.
Terminal Road.
I'll take 5 minutes, Lordship, to give the conspectus and my argument. Then I can take Lordship to the documents. So, Lordship, essentially, it relates to a tea garden. There was a 1955 scheme with the workers, with the union, is replaced in 1971. Now, the 71 scheme clearly determines who will get pension, who will not get pension. Anyone less than 15 years will not get pension.
15 years as of 1971.
Yes, that means at that time, actually 15 years of service on, yes, as of calculated in 71. That has a particular clause 7. Now, 71 is superseding 55, admitted position. Clause 7 says the choice of opting in for gratuity or pension. The crux of the case comes to this. Our case is, Lordship, from 1971 up to the reference in 2013-14, 42 years. And finally, the impugned order passed by the tribunal, 16. In 16, no objection by any worker because everyone opted for gratuity because it gave them a higher amount. Second, no complaint by any worker. Number 3, receipts show them receiving the gratuity. Number 4, they already are receiving pension according to the statutory scheme, being the 80 EPF. That is also the factual position. And final and most important on law, besides delay and laches, there is no espousal. After all, in Industrial Act, a trade union cannot on its own come and raise an objection or raise a dispute. Basically, at the end of the day, it is called the doctrine of espousal, settled law. We have the judgments to that effect. When there is no worker or staff who's aggrieved or who has asked the trade union to do so, this also fails on the doctrine of espousal. There is an
The
error on
reference was made in the year.
2013.
So the employees who were involved as
No
of
employee.
1971, when the 1971 scheme was given operation.
Because
So before 13, they all might have retired.
many may not be alive also, in fairness.
I get it, but they have retired.
Of course. And,
And
which is
the option was 1971.
which is what I
The statute required an option.
this is the settlement between this is
18.
it's an inter se settlement
18.
1971.
No, a settlement under section 18. 18(2)(3), tripartite or bilateral.
It might be bilateral, Lordship.
It is bilateral.
It is bilateral.
So the
It was.
bindingness would be a bit.
Yes, Lordship, this would be bilateral. And in fact, we can go straight to page
Was
50.
it with the before the conciliation officer, or it was between the parties? So
Conciliation
that again would have a different connotation altogether.
Absolutely. That's in 13 only, no?
But
71.
Mr. Kohli, fine, you have a settlement. How was this option, if I may put it, taken to the last man in the line? How did the company put this option, to the last man in the company?
Now, where the problem comes,
Hmm.
and that's the practical part of it,
Hmm.
and I'll be honest because I have to assist Lordship, is between this phase, there are change of managements also. Because in the tea industry, and Lordship would know better than us, but whatever little I have assisted in a few matters, these have never been static. They change hands. And now the present management, which is there for a period of time, it has, and I must point out from 1991, the letters of employment by the present management make that absolutely clear that you are getting your your pension as per the ATEPF, and there is gratuity.
So those are employees who have come into service after 91.
Lordship, logically.
So before 91, is there a finding by the tribunal anyway that this option was never given to them?
No, Lordship, no.
Not there.
Which is what the crux of the case is. It's a unilateral finding, which there are two witnesses, management witness, there is the workers witness. The workers witness has direct contradictions to say such a clause did not exist.
In the settlement.
Yes, but it does exist.
Fine.
On oath. Second, Lordship, with due respect, you have to have someone at least complain. You have stamped receipts of people.
We'll come to the complaint part. It's a beneficial legislation after all. So what is the finding of the tribunal? Maybe you have raised an option that nobody had opted for this scheme at any point
We
of
have
time.
said that.
What is the finding of the tribunal on
Lordship,
that?
there is also a contradiction within that. It on one hand is accepting the argument, on the other hand, it is denying it. There is a direct error also.
So what is the nature of that acceptance and the denial by the?
I'll take Lordship.
We will go to.
So if I may.
So that is the issue.
Yes, Lordship.
Okay, fine.
Lordship may come to 15. Let's see the scheme, just the 3-4 clauses.
Page
15, Annexure A, Lordship. Now, Lordship may just note right at the top, it is agreed between the parties and the existing retirement and pension scheme as per agreement of 25th January 55, is subsequently revised, will be replaced by the following scheme, named as the Retirement Benefit Scheme of 71. 1, that the scheme shall be called so-and-so. It will be in force from 31st March. Let's come to 2, Lordship. Members of the staff and artisan cadre will retire at the age of 58 years or after completion of 30 years service, whichever is earlier. Now, 2 is relevant because it's on the basis of 2, the other things will come. Now, Lordship may come to 4. The scale of pension payable to retiring members under clause 2 will be proportionate to the years of service between 50 and 30 years. Now, Lordship may mark. It is 15 and 30. That means anyone with less than 15 years is not eligible for pension, Lordship. Now, that becomes important because it's not a case that all had to receive it. Now, Lordship, gratuity, which is 6. Gratuity will be paid in the following cases where pension is not admissible at the rate of 15 days wages for each year of completed service up to a limit. And then the most important being clause 7. Employees retiring under clause 2 above may exercise the option of gratuity in lieu of pension as provided in clause 6.
For my benefit, can we go back to 2?
Yes, Lordship, please. Members of the staff and artisan cadre will retire at the age of 58 years or after completion of 30 years of service, whichever is earlier. Now, as a calculation, in 1971, the retirement age is 58 years. Assuming somebody to be even 18 at that time, Lordship, it is 40 years of service. That person in any case stood retired. So therefore, the first question that Lordship asked, that they would have retired by then 100% Lordship, within which also the assumption can be made that all would have stayed for the full.
Fine. Let us have that subpara to 2.
Yes, Lordship. However, employees who have not reached the age of 58 years after entitlement to full pension shall be allowed to remain in service until they have reached 58 years of age, if they so indicate their wish at least 6 months prior to their completion of 30 years of service, provided that their work was previously not reported to be unsatisfactory and they are medically fit. But Lordship, may I read further?
Yes.
Junior staff members will ordinarily enter into service not later than the age of 25 years, but the company may
4. We can go to 4.
4. The scale of pension payable to retiring members under clause 2 will be proportionate to the years of service between 50 and 30 years. So it starts at 15, which is the point I was making.
Now we have 7.
Now 7, Lordship. Employees retiring under clause 2 above may exercise the option of gratuity. Clause 2 has to be read with 4, Lordship, in any case. May exercise the option of gratuity in lieu of pension as provided in clause 6.
So the scheme is the other way around. You are automatically covered under the pension scheme. If you have to move out, give an option.
No, I would respectfully say, because then we can argue, yes, Lordship, I would respectfully say, then the argument of may and shall, and or. Because, Lordship, if somebody is necessarily...
Mr. Kohli, this is not a statute. This is an agreement.
It is an agreement. Yes, Lordship.
So, agreement, you have agreed that everybody will be covered by the pension scheme. If you have to opt out, opt for the gratuity.
Right, Lordship. And our case is that they opted in for gratuity.
Gratuity? That evidence will do.
Yes, so on that,
So,
Lordship,
if they have opted for gratuity, they are automatically out of the pension scheme.
therefore, Lordship, that would be in the evidence. May I take you, Lordship, straight to the evidence? Because what I have, and Lordship...
So, the
bear in
issue
mind-
that we have to now determine is whether there was an option for gratuity.
I bow to that. Now, Lordship, how can I show that? Because in
Evidence.
fairness, just for a moment, I am talking of something that goes back to at least 40 years. And therefore, Lordship, the evidence has to be seen in the nature of whatever can assist me to that. And I will show that there are stamped receipts of people receiving gratuity. And there are judgments to that effect also.
Okay, what is the conclusion reached by the...
Your Lordship may have to bear with me 5 minutes.
Okay.
Because what I will do, Lordship, before I take you to the conclusion, I must show you the 2 affidavits which are very short.
Okay.
Now, Lordship, may just take my basic 5 arguments at this point. Is that there is no objection by any workman on the applicability of clause 7. That's my first point. No objection. Because if there is an objection, there would have been an industrial dispute. Acha, Lordship may also mark on page 7.
Application of clause 7.
Yeah, Lordship, no objection. Now, Lordship may please mark that the trade union is a signatory to this along with the company of the 71 scheme. That's important because it is the trade union which is the signatory. Page
Where do I get
Page
that?
17, Lordship.
Industrial Disputes Act.
Come. Page 17, Lordship. 28th of July, 71, Zonal Officer, Assam Sa, Karamchari Sangho.
By letter.
Now, Lordship, because this industrial dispute 9A reference will become important in law. Second, Lordship, no document. So, my case is no objection by any worker. Counter, no document produced by a workman or the union to show they opted for pension and did not get it. 3, Our consistent stand is everyone opted for gratuity since that is what they wanted because of the higher benefit. No evidence that contradicts my stand, Lordship. Next, Lordship, please come to page 18 for a minute.
Yes.
This document on 18, which is 29/5/2013. This is, Lordship, to the managers, etc. Lordship may note, I am to enclose two numbers check dated so and so, numbered so and so, dated so and so for 3 lakh something. State Bank of India, Dispur, in respect of pensionary benefits of the seized members as per statements in your duplicate enclosed. You are therefore required to hand over the check to the persons in the presence of the primary committee members after verification to avoid double or irregular payment and forward the original. Now, Lordship, this document confirms pension is being given as per the statute.
That is the gratuity.
Absolutely, Lordship. And there's pension. Lordship, I'm saying pension. Lordship, there are two things being paid. Please mark the top of the page. This is on the top of the page of 18, Lordship. It is the Assam Tea Plantation Provident Fund and Pension Scheme. So there are two parts. What our case is, they get
Mr.
gratuity.
Kohli, just a clarification. Sorry to stop you. What is the pension that you have contemplated in page 15? It's a pension given by the company itself.
I must make that clear. This is, so originally 55 was pension by the company. Then of course, Lordship, as the statutes come, Gratuity Act came. So gratuity becomes payable. From that point onwards, there is a statutory requirement to pay pension. That's also being done. So our case becomes that the tribunal holds you have to give gratuity, statutory pension and company pension. This is what the crux of the case really falls down to.
That underlying thing would be gratuity is something which you have to pay under a statute.
Yes.
The scheme, PF scheme, is because your contribution and his contribution were being deposited there.
Right.
So that deposit is different.
Right.
Third, the company thing because of the agreement.
Right. And our case is therefore built on this, that there is no industrial dispute and therefore it is incorrect because there is no complaint by a worker till date over 40 years, delay and latches, and the doctrine of espousal will also reject the
So today I understand that
Gotcha.
the workmen who were there, on whose cause the exposal was made, they were receiving gratuity and the PF.
eventually. Right.
Eventually, these two benefits they were receiving. They were not having the PF scheme, the pension scheme.
Pension. The third. Our case is that the choice was to be given at that time, way back in 71 with the enactment. What do you want us to work on? Which is where this agreement comes into being. And our idea is that our argument will be hinging on the fact that for the tribunal to have passed an order in the first place, it is basically, according to me, respectfully, it couldn't have done so in the absence of an industrial dispute existing.
Fine, we'll come to that.
Yes, Lordship.
We'll
So
come to that. But
now,
poor
Lordship,
people, the laborers are there, so we will go a bit slow on that.
So, Lordship, I must make this clear. This is not labor class.
These
See,
are
then again come back. This is only for the staff.
staff in the office.
Yes.
Not the
Additional- No, Lordship, this is not for labor because labor then has
Now,
the-
now, Mr. Kohli, Mr. Kohli. If, let us go back to 71. If this pension scheme was introduced and people accepted it, would there still have been a requirement on you to make deposits to the Provident Fund?
statutory requirements are there. Go
You will
without
have-
saying, Lordship.
This would be done. In addition to that, you are paying this. Okay.
No question about it. Now, Lordship, just to complete the evidence, because the evidence makes it interesting, Lordship. The written statement of the management is at 21. Then I'll take you to the cross and come back to the order. Page 21, Lordship. Now, Lordship may note our written statement, page 2, or rather page 1 bottom, para 2. That the retirement benefit scheme of Jorhat Tea Company Limited was introduced as a second terminal benefit in addition to the
Okay.
Provident
Now,
Fund.
this is clear.
Much before the present management took over the affairs, para 6.7 of the scheme enclosed clearly stipulated that it was an alternative to the payment of gratuity to the employees. In fact, over the last few years, the retiring employees always opted for payment of gratuity in lieu of pension because statutory scale for the benefit of payment of gratuity compounded with rising wage levels of employees brought the employees substantially higher financial benefits than the employees would have been entitled to under the pension under retirement benefit scheme. that in actual practice for the last few years, till date, the retired employees have always opted for payment of gratuity. Hence, the present pension scheme has ceased to be in vogue. And since the enactment of the Gratuity Act, the management has no instance of paying pension through the scheme to any of its retired employees. As such, the question of pension scheme, which is not in existence in all reality, should not arise, as the management will continue to fulfill the statutory requirement under the Gratuity Act of 72. So this 72 is the act, this is 71, into all its retiring employees. Para 4, Lordship. Or may I read, Lordship?
Yes, yes, please.
That the management has considered the situation and in view of the fact that substantial benefits are being provided to the employees under the statute or otherwise, and the employees have never raised any dispute regarding alleged non-implementation of the settlement term, and accepted the gratuity amount without any demo and protest in lieu of pension. Then 5, the ACKS, being the union, Nahar Katia Circle, is raising such issues on behalf of former employees who are no longer employees of the company, which is bad in law and fact. And the third leg of the argument comes in 6, that in the appointment letters of the employees who have joined since 1992 contain a specific clause that employees will be entitled to gratuity under Payment of Gratuity Act, pensionary benefits under the provisions of the ATPPF Act and rules, and accordingly the management is paying all statutory obligations and terms of settlement stands merged in view of such subsequent development, and in subsequent to entering into a settlement agreement, there have been significant changes in labor legislations in the regional level, and terms of the settlement somewhat become infructuous, and the management subsequently has been extending several benefits under the respective statutes, which amount to more than what the employees will get in the event of settlement terms will be implemented. Please mark, Lordship, the employees have accepted such positions and have never raised any dispute or issue regarding the same. The same is tried being an issue as this being belated aid only for unduly enriched. I think
The agreement that is there in 1971 will only bind the employees who were there and the employer. 92 onwards, this will not be happening. It will be covered by this only.
Now we must go further, Lordship, to page 27 being the statement of the
Workmen.
Now the workman statement doesn't come from a worker. It comes from the union. That is important. Lordship may note that one is very critical, Lordship, that the Assam Sar Karamchari Shongho Nahar Katia Circle is a registered trade union affiliated to INTUC and has been espousing, Lordship may mark this word, the cause of members employed in different tea gardens within the territorial jurisdiction. 4, it refers to the scheme of 1971. 5, promulgation of the Payment of Gratuity Act 1972, which came into force on 16/9/72, the management of Jorhat Tea Company arbitrarily stopped the retirement benefit scheme without consulting or prior information to the representative union and offered to pay gratuity only as per this.
Mr. Kohli.
Yes, Lordship.
I think this is a very important statement there, para 5. What is the finding of the tribunal on this? Just for my
2 minutes, Lordship. I am sorry to say also, Lordship, that the tribunal doesn't make a finding in that way. It goes on to put the issues. So, Lordship, because this was the question Lordship asked me also earlier, indicated to it. Now, Lordship, we come to 6. That the referred agreement scheme was signed much before the enactment of the Payment of Gratuity Act, and there was no provision. Please mark this. This is lying on oath, Lordship. And in the cross, he will admit and say, yes, there is that. That there was no provision, and their objective will become clear there, that it is not to do with the workmen. That there was no provision of the agreement to pay gratuity in lieu of the pension. It's a false statement. Lordship may come to 8. 8 will become a legal point just now, Lordship. That the management's decision for stoppage of the pensionary benefit to its retired employees without giving proper notice as required under 9A of the Industrial Dispute Act 47 is not only amounts to withdrawal of privilege but also violation of principles of natural justice. Then, Lordship, the others we can skip for now. Yes, Lordship. Let's go to the cross. So I'll now show Lordship the cross. So I close the chain of documents, then come to the evidence file is lordship separate. It's lordship this. There is an evidence file lordship. We had marked it also lordship. We may need the assistance of. In it, we had marked XXXX, which is the cross. Three documents we have to show. Just only 3 documents have to be shown. May I assist if the documents lordship would desire? I can assist the court.
I have the original LCR with me. You can take me to the.
So lordship, it
Relevant.
says internal numbering of the page is 153 on the top. We have flagged it with a XX. On the top, it might be a green flag.
Green.
XX.
150, Exhibit 17, 153.
3. It is lordship the deposition of the workman witness 1.
Witness 1, yes.
Have you got it?
It's 172.
Okay, lordship. Just make a note of the page. Of 19. 172. So, lordship, the deposition of workman witness number WW1, aged about 46 years, taken in oath or solemn affirmation under provisions. Lordship may note the date. Sri Mridul Medhi. Father's name is given. Please come to the cross. Bottom of the page. I am the secretary of the Assam Sah Karamchari Shango, Nahar Katia Circle. Then third sentence. I know exhibit 1 in para 7, where it is disclosing employee retirement under clause 2 of exhibit 1 may exercise the option of gratuity in lieu of pension as provided. We have shown the statement he says doesn't exist. I have mentioned in my affidavit in para 6 that there is no provision to pay gratuity in lieu of pension. We want, this is the objective, a revision of the settlement agreement in relation to payment under employees retirement scheme.
So this he is a member of the union.
Yes, Lordship. Not a worker. That's important because this will be on the law point, Lordship. Lordship may turn the page. Now, very important, Lordship. The first sentence may mark, I have not mentioned the name of any worker who sought for getting gratuity and also pension. I have not submitted any list of workers who are willing to get gratuity and pension benefit. It is a fact that the appointment letter of the employee of the tea estate who joined since 1992 contained a specific clause that employee would be entitled to gratuity under the Payment of Gratuity Act pensionary benefit under 80 PPF. At present, the management of the tea garden are paying the gratuity as also pension benefit as per the rules. All retired employees opted for gratuity in lieu of pension and they are receiving accordingly. Without revising the previous agreement, our issue of this reference cannot be settled. I have not submitted any kind of documents pertaining to the worker who raised the issue for the reference. It is not a fact that we are harassing the management by filing this case without getting any complaint from the worker.
What are you reading?
I'm reading the Bible, this one. Last sentence, Lordship. It is not a fact that we are harassing the management by filing this case without getting any complaint from the worker in relation to the matter of pension and gratuity. Lordship, the law is, there is a doctrine of espousal, Lordship. That is the settled law in industrial dispute. Union can espouse the cause of a worker, even if it's a single worker, Lordship. But union cannot unilaterally, in the absence of a worker, Lordship, because it does not form part of the definition. That's the law, Lordship. Now, Lordship, if Lordship would like to see our cross is only a repetition, one document Lordship wanted to see whether we were making payments. Now, Lordship, this is, since Lordship's document is 19 added, this might be
The management witness number 1.
Yes, Lordship. Only one witness each.
Bishal Singh never.
Yes, Lordship. We have already said in the first paragraph it is still in operation, Lordship. It is true as per record that the union, please come to the third last line, Lordship. It is true as per record that the union has continuously been raising the issue before the management regarding revision of the agreement. So they want a revision of the agreement. It's not an industrial dispute. That's the crux of it.
Okay.
Now Lordship may consider for a minute. This may be Lordship this is 27? Yes, 27 plus 19, 30, 46. It is marked Lordship this. It's annexure B. This is document number 2. It's document 2.
Not an exhibit.
So what?
What is that document? Annexure.
Annexure B Lordship, it shows the payment of gratuity. It's a chart like this. He has actually marked it Lordship on the last date. 23. Page 23 Lordship.
Flag mark with what? There are only flag marks here.
Unfortunately, I saw that and kept quiet Lordship.
I've got it. A document number 2.
Yes, Lordship. Now, Lordship may just note, if you may, Lordship, I'm sorry, it's old document, so it's not. very clear, but
87.
come to
Ian
the-
Bodley.
Yes, Lordship. Please come 4 columns to the left, Lordship, from the right hand side, 4 columns. Years entitled for gratuity, it says, Lordship. Amount payable, Lordship. Paid on, Lordship. And finally, revenue stamp confirming the authenticity and payments made. Okay. Now, Lordship, respectfully, if there is a dispute, they have to bring some evidence to that effect, Lordship. It can't be just a dispute. We may go to the award if Lordship will be pleased. Lordship, that stands at page 31.
32 is the terms of reference.
Yes, Lordship. And if Lordship would be pleased to come straight to para 12, Lordship marks the exhibits that are shown, Lordship. And Lordship, the evidence starts at page 39, para 17.
We have seen that.
Right, Lordship? Now, issue number 1 is dealt on 42, Lordship.
Issue number is whether the management so and so is not paying pension as per the terms of to their employees who have retired or will retire from their services. Okay.
Yeah, clear contradiction. वो दिखाएंगे contradiction. Now, Lordship, just before I go, if Lordship would permit me, I'll show the 2 contradictions. Then I'll come back. There is a contradiction between para 12 and para 25. With respect to that, with the document 2. So that's what I'm going to show, Lordship, is the contradiction first. Then I'll come. In fact, Lordship, I have given a written submission.
We'll go through that. I don't want to be.
So
I want to understand it.
Yes. So, Lordship, in para 12, it says about it, it acknowledges the existence of Exhibit B, record of former retired employees who adopted and received gratuity in lieu of pension. Has Lordship got that?
Yes.
Now, Lordship may come to 25. Just let's get over with this one part, Lordships. Lordship may come to the 5th line from the bottom. There is also no evidence on record to say were the employees opted to receive gratuity in lieu of the pension.
So that document 2 was there.
And in 8, that finding is there. Yes, there is evidence. In 25, it is contradictory.
Okay.
That is a just short point of the error.
Yes, fine.
Now, Lordship, having done that, we can come back to issue number 1, para 12, Lordship. Just 3-4 paragraphs are there, Lordship.
21, para
yes.
21.
You are at 21, Lordship?
No, fine. Wherever you want me to take.
Yes, Lordship, I'm sorry. It is 21.
21.
Yes, I stand corrected. It is admitted fact that the management has not been paying the pension to the retired employees after the enactment of the Payment of Gratuity Act, but the management opted to pay the gratuity in lieu of the pension, though there was a bilateral agreement signed on 1955 by the union and the management, which was subsequently revised on 28/7/71, where there was a provision for giving pension to the retirement employees or to the retired employees. It was a choice. The management took the plea that the retiring employees always opted for payment of gratuity in lieu of pension because statutory scale of benefit of the payment of gratuity compounded with the rising wage level of employees brought to the employees substantially higher benefits that the employees would have been entitled to in terms of the pension under the retirement benefit scheme. It is seen from the evidence on record that the retirement benefit scheme of 1971 was formulated through collective bargain effort, and settlement was arrived at by and between the management and the union of the employees. And there is no basis for the management to deny that the benefits under the retirement scheme merely because gratuity had become payable under the Gratuity Act. In fact, the management is under obligation for payment of pension under retirement benefit scheme as well as gratuity under the Gratuity Act. Now, Lordship, I am of course taking the point that this finding itself cannot come in the absence of the espousal by a worker. The benefits receivable under the retirement benefit scheme dated 71 has clearly disclosed about the payment of pension to the retirement employees and to the to-be retired employees from para 1 to 5 and para 6 and 7 disclose that the mode and payment of gratuity. But after the enactment of the Payment of Gratuity Act 72, the management stopped payment of pensions with effect from September 72 to the retired employees and only paid gratuity by ignoring the settlement arrived between the employees union and the management in relation to para so-and-so, which is clearly violation of the provisions of Section 9 of the Industrial Dispute. So now, this is the finding against me. What my counter argument is, Lordship, that Section 9A has to be read with the 4th schedule. Clause 8 deals with withdrawal of a benefit. There is no withdrawal, our cases, because in effect, it wouldn't have applied to those less than 15 years. So it wouldn't in any case. Second, everybody receives. I've got evidence to that effect. 3, there is not a single case of anyone complaining or making them espouse the cause over 42 years, 43 years. Let's go, Lordship, to para 25, just the line above it. So therefore, Lordship, he holds, the tribunal, the issue is decided in favor of the union. I will come to the law on Section 9A very shortly. This is where my main problem comes from, that it's an incorrect application of the law, in addition to the factual matrix. Now, Lordship, in 25, the tribunal deals with issue 2 and 3 together and says, as per the evidence of the management witness 1, that for the last several years, the retiring employees always opted for payment of gratuity in lieu of pension because the statutory scale of benefit of payment of gratuity compounded with rising wage level of employees brought to the employees substantially higher financial benefits, and the employees would have been entitled in the form of pension under the retirement benefit scheme. The management has failed to prove how the employee would be highly benefited who opted for gratuity in lieu of pension under the scheme. How can this be an issue, Lordship? Respectfully. There is also no evidence on record to say who were the employees who opted to receive the gratuity in lieu of the pension. Reverse, is there evidence of anyone saying that they did not receive it? How can the act be applied by turning the entire onus on me? As no written documents are produced which would prove that some employees applied for getting gratuity in lieu of pension. Pause. Not a single document saying that we did not receive it or we wanted it and we didn't get it. I mean, complete reversal, Lordship. The burden is shifted in.
Mr. Kohli,
Lordship.
we have gone through. If you can come to para 29,
Yes,
the
Lordship.
final direction.
Yes, Lordship. Order.
This is an award. It has to decide the issues finally, either this side or that side. It should be given a finality. Now, what is the purport of this direction according to you?
Therefore,
In view of the facts
and circumstances and settled legal position, I don't feel any hesitation in holding that the action of the management regarding refusal of pension, there is no refusal, Lordship.
and paying.
The gratuity to the retired employees is neither legal nor justified. Accordingly, it is held that the management is hereby directed to make a bilateral agreement.
So, there ought to have been a direction that this is the conclusion. Now, whoever had got gratuity, however you do it, you give them pension. But if it is a bilateral agreement now required to be brought in again, there cannot be a direction for the retrospective benefit.
Yes, Lordship.
Please, 2 minutes. Yes, Mr. Madam. I'll pick up from where we have left.
I'm great.
Just a clarification. Madam, we'll come to the law. Just to understand. Finding it, because this is something new for me. Industrial matters. You are veterans in that. So I'm picking off. Madam, there can be a gratuity scheme or a pension scheme. Both can't go together. From the company side, not under the Payment of Gratuity Act. In 71, the situation is either you get a gratuity or you get a pension from the company, because Gratuity Act had not come into operation. 72 only. Now, the affidavit that you have filed, or the written statement that you have filed before the tribunal in the reference case, come to page 28, para 5. So this is a fact which had come into being in 1972. I'm just trying to get a clarification. In 1972, there is a milestone put wherein the company decided that we will not now pay pension. You are entitled to gratuity under the Act and the PF, the Tea Garden, that Provident Fund pensions. But why was no objection raised from any worker or the staff against this? Because your evidence does not bring on record that. That is what, madam, they will have to understand one thing. The agreement, bilateral agreement, will bind only those who were there on that day in 71, employees. And the management would be bound to pay those particular set of people who were there from 1971 till 1992, when the management says that we have been giving this option or this condition in the appointment order. But in 71, the gratuity that is contemplated therein is not the gratuity under the Gratuity Act. It's a benefit which is culled out or agreed upon by the company.
My lord, they get.
That's what I'm saying. 1971 gratuity under the 1972 Act is not even contemplated. So therein, it was pension per se. And you ought to give an option, and thereafter you will be paid the gratuity. At that point of time, gratuity was a higher value, so you opted for gratuity. Now, that statement, that factual matrix is in para 5. That the respondents, or the company, whoever was there, company from 1972 stopped the pension scheme and introduced the 1972 gratuity. Cannot be. Then did you refund? Madam, where is your stand in the pleadings that we are ready to refund the gratuity amount with interest? You are not entitled to both in 1971. Madam, no, the gratuity scheme came in 1972. 1971, when this was done, gratuity was in lieu of pension. That is what I'm saying. That is what I'm saying, madam. That is what I'm saying. That is what I'm saying. Kindly, I've told you, now this takes some time to come out from my head. In 1971, the pension scheme that was introduced was a pension scheme of the company. They said, they were very benevolent, they will pay you. If you don't want that, give an option and take gratuity. This position continued till 15 to 30, that service, fine. But your own statement in your written statement, your own contention, that on 16/9/72, the company stopped the pension and went under the paid the gratuity under the 1972 Act. Now, where is a grievance raised against this? Because the reference was raised sometime in 2015-16. So from 72 till this time, who are the employees? Where is your list of employees who have now staked a claim that we will be requiring the pension? This gratuity that is there, and the gratuity under the 72 scheme act and the rules, and the gratuity which was there, those are different. So there was a pension scheme introduced, or a lump sum amount. We'll not call it gratuity, it's a lump sum amount. Lump sum amount given. The lump sum amount was very attractive, so that was taken by the employees. Now that, once you receive that, the relation of employer-employer is severed. Where is the dispute raised by those employees that, see, give us? This is only the employee, the union one day finally working up and then going. Please, you let it, not a wrong submission. I want a correct position from you.
To section.
Okay.
Presentation of parties.
That is it. That is it. That's it. So the dispute here is not of the union. The dispute is of some workman of the company. Represent. Where is that? Who is that person raising that dispute? Or the class of persons raising that dispute? They cannot. They are only an attorney holder. Where is the principal? I got it, madam. I got it. I have dealt with matters by the Ashok Sangha, but they were doing it for a particular workman or a class of workmen. Here, if you can see, a workman who is a party to a dispute. Party to a dispute. So, which is that workman who is party to the dispute represented by the union? Who? Where is that? Where he has raised a complaint? I'll not use the word dispute. Where has he raised a complaint that this benefit, give it to me? How? Madam, this is not a trade union meeting. It's a reference. That system will have to stop that. There has to be a grievance of a person. There has to be a grievance of a person which can be espoused by a union. Okay, show me the statement or your material to show that this workman had come before you and then you took up the issue. You cannot take up the issue in air. This is not a PIL. Now, madam, you come to para 29, page 47 of the paper book only. The petition, page 47. Paragraph 29, madam. Finding. Now this first part, we are very much clear. We understand. But what about the second part?
Holding the action of management regarding
Hmm. Hmm. So, madam, who are these retired hands and who are the retired employees?
their name is not
Where is your list of that? No. Now you did not have on that day when you went to the reference, when you submitted the evidence that these are the people who are aggrieved for which I am before your lordship, before the court tribunal. Because there is a specific question in the cross asked that where is the list? The list was not produced. So, in 72 to 2016, what was the nature of the grievance redressal mechanism that the union had followed, which led to finally the reference? Because this grievance is there from 1972.
making submitting
Where is your evidence to that effect? Where is your evidence to that effect? No, the evidence of the workman. Only one workman had deposed. So this is now, where is the evidence to that effect? Madam, you have the evidence of the workman? You can just take me through that relevant portion. Then we can ask Mr. Kohli to make a response. Second page of that.
No, not in-
173. Madam, towards the end, the second page. I have not mentioned the name of any worker who sought for getting gratuity and also pension. That for me is not very important. These are poor people. But what is troubling me is 1, 2, 3, fourth paragraph. All the retired employees opted for gratuity in lieu of pension and they are still receiving accordingly. So there is no dispute on that. Without revising the previous agreement, our issue in this reference cannot be settled and disposed of. Then why the dispute was raised before the tribunal in the first place? Okay. Now we can just think over it. And when you make your submissions, kindly deal of this issue. Yes, Mr. Chal.
So, Lordship, on the facts, I'm done. I have to now shift only to the law. We have Lordship given in the past compilation.
Yes, it's there.
Has Lordship got that?
Yes.
So, Lordship, if Lordship would just see right at the beginning, what are the propositions, then I'll just take you through the relevant paras. The first proposition is without prejudice to other submissions, after full and filing, nothing more can be asked. Full and final payment, which is that stamp thing, Lordship. Then
The employer-employer relationship is not there.
yes, Lordship. Then there is delay and latches. Then there is beyond the terms of reference. No valid espousal, which is an essential ingredient of industrial dispute, and agreement not under the Industrial Dispute Act. And the last is gratuity, clearly an alternative to pension. So, I mean, we've divided the 6 propositions, Lordship, and we've got these 1, 1, 2, 2 paragraphs in each judgment, Lordship. Yeah, Lordship. Or Lordship wants me to do it tomorrow morning. I'll stay back if Lordship keeps
I'm
it.
sorry, I'm not here tomorrow.
Oh,
We can
I
get
can
over
continue
with this.
as Lordship.
We can get over with this.
Yes. Shall I continue?
Yeah, please. Just a moment. Give me 2 minutes.
I won't take you through all, Lordship.
No. Madam, another issue which I would like you to address is this agreement of 71 at best is 18-1. At best. So it is between the employees there at that point of time and the management. Now, if we see para 29 of the judgment, any person who has retired from the date prior, just a day prior to the date of the judgment, till the person who was there in 1971, everybody is covered, which cannot be because of the clause in the appointment order from 92. And you have not exposed the cause of those people in this writ petition, in the reference, because you have not challenged that. Nobody has challenged. So this would be in relation to persons who are there prior to 92. Before that conditionality came in, and who had 15 years, completed 15 years. But they have no grievance. You yourself say that you don't have a list. You don't have a list, then why this big? Okay, fine. Just make a note of that when you make your submissions. Yes, Mr. Kohli, you can
Lordship,
take
for
me
page
through.
1, Madras High Court, Lordship, 1967. First paragraph. An important and interesting question of law arises in these writ petitions, namely whether receipts passed by the erstwhile workmen to the management in full settlement of their claims at the time of closure of the business would stop them from claiming full statutory benefits conferred on them under the Industrial Dispute Act. So this is here, of course, Lordship. We are taking a look at the gratuity, but even under the Act, let's go, Lordship, straight to para 11 on page 4. There seems to be a difference in the wording of the section between retrenchment compensation and closure compensation. I'm not touching that. Page 5, Lordship. 3rd line, 4th line from the top, right?
Signing of this stamp.
Yes. The signing of the stamped receipts in full and final settlement of their claims is an intentional act. The intention being to treat the matter as if the condition did not exist or as if the breach of the condition has not occurred. And that's why that stamped receipt signature is important. No breach. The workmen signed the stamped receipts with full knowledge of their claims. The conduct of the workmen in refuting their own receipts is an act of approbation and reprobation. The conduct of the worker may also amount to estoppel, for they
There
were
is no worker disputing that here in our case.
none, Lordship. So therefore, next, Lordship, page 6 on delay and latches.
That will go. You
No,
can take me straight to that exposal part.
I'll come to this puzzle. The Lordship may just mark the paras. I won't even read.
No, it's already marked here.
I'm great. The Lordship will go to 103.
I'll take note of each and every, I'll read that, but
Great.
just to cut the time short.
105. Yes, of course, Lordship. 103. Lordship, this relates to the Hindu newspaper.
That is what I
It's
want.
an interesting thing. So espousal is an essential ingredient of an industrial dispute. Lordship may come to 107. Para 9. Just one para. By its constitution, the Bombay Union of Journalists is a union not of employees of one employer, but of all employees in the industry of the journalism in Bombay. Support of the cause by the union will not, in our judgment, convert the individual dispute of one of its members into an industrial dispute. The dispute between the Hindu Bombay and this is Salivati Swaran was in the respect of alleged wrongful termination of employment. It would acquire the character of an industrial dispute only if it is proved that it was, before it was referred, supported by the union of the employees of the Hindu Bombay or by an appreciable number of the employees. The workmen of the Dimakuchi Tea Estate versus management of Dimakuchi Tea Estate, this court held by a majority that the two tests of an industrial dispute as defined by subsection K of section 2. So, Lordship, my sister referred to section 36, that has to be read with 2K. Of the Industrial Disputes Act must therefore be 1. The dispute must be a real dispute capable of being settled by relief given by one party to the other, and 2. The person in respect of whom the dispute is raised must be the one in whose employment, non-employment, terms of employment or conditions of labor, as the case may be, the parties to the dispute have a direct and substantial interest. And this must depend on the facts and circumstances of each case. In that case, certain employees sought to raise a dispute about a person who was not a workman. In the present case, members of the union who are not workmen of the employer against whom the dispute was sought to be raised seek by supporting the dispute to convert what is prima facie an individual dispute into an industrial dispute. The principle that the persons who seek to support the cause of a workman must themselves be directly and substantially interested in the dispute, in our view, applies to this class of cases also. Persons who are not employees of the same employer cannot be regarded as so interested that by their support they may convert an individual dispute into an industrial dispute. So, Lordship, the next at page 114. This, Lordship, is Delhi High Court. And I'll, Lordship, in this case, just read A and B recite on top. Industrial dispute, what is sponsor or espousal of dispute by a union of the workmen, whether essential. In order for a dispute to be an industrial dispute, it must satisfy the definition of section 2K. A dispute between any individual workman and employee can be treated as a dispute only where the workmen as a body or a considerable section of them make common cause with the individual workman and espouse his demand. Got it. Right? And B, Lordship. At
That is para
170
9, 10
para 9,
and
10. Yes, Lordship.
13
And 13 and 14.
13.
Yes, Lordship.
Then you have Bombay,
Bombay, Lordship. At 124.
124, para 14.
But, Lordship, those two judgments, according to me, deal with the entire issue.
And what is that? Delhi one also same lines?
Same line. All on same line.
The agreement under the ID Act, it's an agreement. It can be at best 18-1.
And, Lordship, in this case, which is the crux of the issue, is there is no espousal.
Now I understand why you were so insistent on having this espousal part. Okay.
It's the law, Lordship. I'm so grateful.
Yes, madam. Trying to pick up certain paths because this is something very new to me.
Yes, Lordship, it was new to me too. So, Lordship, I had to read this for the first time, I must tell.
Yes, madam.
Lordship, may I be excused? But the other matter.
Please, please do. So, you, junior should be
colleagues, my
colleagues. Yes.
I'm so grateful, Lordship. Would Lordship require another date? If it is so.
When would it be convenient to you?
Next week, Lordship, 27th, 28th.
28th would be fine. But at 2 p.m.
28th, Lordship.
2 p.m.
2 p.m. Oh, I'm grateful. That's perfect, Lordship.
2 p.m. We'll hear, madam. If she has some trouble, others will close. Others will close this, madam, because your written submissions is there, madam.
Grateful.
My lord, here state that
Yeah, in the. Onidhar Kolita is your junior. Is this the one, madam?
synopsis estate. Synopsis and one.
A statement of facts. Yes, 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 yes. Yes, 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 yes. Yes, yes, Honorable. You have a statement of facts in brief, statement of facts in details.
Respondent number one was
No, no, we'll read it, ma'am. You just give me the essence of your argument.
presented by the Assam.
Okay, ma'am. I understood. Understood.
This which
I got it. I got it. I got it. It's like a writ petition and a PIL. Right? A PIL can be filed by anybody espousing the cause of somebody or a class of people. You need not have your locus given, disclosed there. But when you're in a writ petition, just to understand the issue, in the writ petition, an attorney holder can also file a writ petition on being empowered. And he will be espousing the cause of the principal and the grievances of the principal, but espoused by somebody else. Here, the union is not espousing its own grievance. It is espousing the grievance of someone. Now, where is that someone? Who is that someone who has that grievance? And where is he in the present proceedings? Where is his statement in the present proceedings? Are they employees of that same union, the same company? I'm not on that, madam. Here, this is a specific. Let the union will take every step here. There is no doubt about it. But where is that person having a grievance?
was on record.
It's not there in the pleadings and the statements also, in the deposition also. Mr. Kulta, normally in a proceeding, there is a person with a grievance and the matter is taken up by the union. It cannot be a situation where the union has a grievance and comes up.
Cross or adduced evidence by the workmen also.
There has to.
Yeah, there has to. Because
Say, ma'am,
knowledge
in a departmental proceeding, say
because
some
of
workman is put to trouble in a penalty is imposed. The union can very well do it. But his statement in the inquiry would be very required because it's he who has a grievance.
because lots of knowledge.
Knowledge.
The knowledge.
Okay. Madam, you formulate your things. We'll have it on 28th at 2 p.m. I'll go through now. You have given me a list of documents. We'll see on the next date, madam. But whatever the thought I transferred, if you can also encapsulate that in your arguments, I will be very grateful for.
Typically, responses are harping on the judgment of this honorable court Boisabi, which has been distinguished in our written argument also.
That distinguishing should be made by decide.
Our argument, lordship. Our argument.
Understood. Arukita, sir. Yes. This is Deputy Commissioner here. Hmm. Deputy Commissioner Lakhimpur, with regard to operation of a fishery. Huh? So, huh? Yes, yes, yes. Contempt matter, Deputy Commissioner. But nobody is appearing. I can't close a contempt matter like this. I'll have to either have it implemented or say it's not possible to be implemented. You have your instructions here. Copy to Dioctem. Mr. N. Das, learned government advocate, is requested to receive instructions from the district commissioner, Lakhimpur, with regard to the compliance of the directions passed by this court via the order dated 6/1/2017 in I number 2844/2015 bracket on in WPC number 6346 of 2015. Registry to list this matter again after or list this matter again on 15/9/2025, reflecting the name of Mr. N. Das as the counsel for the N. Das government advocate. You cannot be the counsel for the respondents.
Copy of the petition also, if
Huh?
possible. Copy of the petition, if possible.
Oh, nobody is there to ask you to give you that. You take a note from the order here. Yes, madam. Here for so late in the day, huh? That.
Land acquisition meeting.
Ah.
Instructed us to file an affidavit. I have filed one.
When? Today?
Yesterday we have filed. On 19th. Oh. I have furnished copy. Given to APDCL also.
Take the, my lord. In brief, my lord. My lord, my lord. My lord, today, my lord. My lord. Tomorrow will be on the.
Lordship, I have a prayer, my lord. One thing is that, my lord, in joint verification, only 9 petitioners' names have been recorded. There are 62 petitioners. Left out petitioners' case may be considered, my and yes, yes, my lord. Yes, yes. Yes. Additional activity. Get maybe. Much obligation. Retrospective effect, they have given lordship, but not from, because I was serving in the higher post all along. I don't know whether is what my limited whatever my limited understanding I have, because in this law I'm very poor. Whether those will be much, because at the end moment I got that, I think I would have gone through in much more details. But
Yes, yes. There was no. working as inspector. At district officer post. So that for
No, after inspector is development officer. Development officer, then the next higher post is district officer, Lordship.
the post of development officer.
But I have officiated. Official, vacant post.
District officer. Yeah.
But retrospective, it's given only from half of the time, but I was holding the post much earlier, Lordship. Office order dated 10/3,
2013.
2013, but I was officiating the post from 2004, Lordship. After the gap of, and 2014, by order dated 10, yes, Lordship, 10/3/2014, Lordship.
18.
Not page 18. It's page 19, Lordship. Yes, Lordship. With retrospect. Yes, Lordship. Ad hoc order is charge of district officer is at page 14, Lordship. Page 14, annexure 4, Lordship. In charge district officer. Come. As a stopgap arrangement, and I was working. Mhm. 2013 July, exact date is Lordship. 17/7/2013. Yes, Lordship. District officer. Other one. No, no. The development officer. This is at page 13, Lordship. Talukdar development officer officiated to district officer. I was officiated in 2014, Lordship. 31/12/2014. Yes. And Lordship, I was officiated as district officer in 2004, Lordship. 6/8/2004, page 13, Lordship. Inspector functioning post is, I was inspector, page 11, Lordship. Ramnath Talukdar, I was presently posting inspector, and development officer, I was functioning the post. Yes, Lordship. Regular promotion. Huh? Officiated, all are from me, sir. These are all. Yes, Lordship, what I'm, that I need to just confirm. Yes, Lordship. Yes, Lordship. Yes, Lordship. MSD good. Forty-four. Pathar, let it be Pathar, Lordship. Then maybe little earlier. Pathar, Lordship, it came to you. Security.
Lordship, may I please mention item number 47? Was substantially argued by Mr. Kohli. Let the matter be kept parted, Your Lordship. For 20th at 2 p.m., Your Lordship have kept it. It's fine. Oblige, Your Lordship.